Good afternoon. We're going to come to order now. Apologies for the slight delay. But good afternoon and welcome to the June the 2nd convening of the Baltimore City Board of Municipal and Zoning Appeals. Before we get started, a couple of house rules. First, you'll note that there are a number of microphones arrayed around us up here, and those microphones are all very sensitive. They're not only for the purpose of amplification, but also for the purpose of recording these proceedings. And for those reasons, we ask that you please, at a minimum, turn any electronic device you may have, anything that makes any kind of audible electronic noise, anything that plays a ringtone, rings, chimes, beeps, etc. We ask that at a minimum those devices be turned to a vibrate only, if not off position. Similarly, to the extent that you need to have or you'd like to have a conversation, we ask that you please take those conversations out the double doors to your rear. As cell phones and the like going off in the gallery or conversations interrupt not just the recording of these proceedings, but also the general conduct of these proceedings. We will be voting at the end of the day, and you're certainly more than welcome to sit around and enjoy a civics lesson if you so choose, but if you've got other plans for this rather gloomy June afternoon, that's certainly understandable, and you can call into the zoning board office in the morning and find out how we ruled in your case, thereby not having to stick around. I'll read the number for the zoning board off a couple of times so you can get that number down. Number for the zoning board office is 410-396-4301. Again, that's 410-396-4301. You will, however, need to wait until you receive the formal written outcome of your case. That should be forthcoming in about 3 to 4 weeks. We certainly ask that you please not build in the city of Baltimore without first obtaining proper permits. If you've not already done so, please sign in on our sign-in sheet, which is being held up by Mr. French. The sign-in sheet allows us to know generally which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices I just referred to. If your case gets postponed, we need to be able to contact you to let you know when your case is going forward as well. So if you're here in opposition to any case, please make sure that you've signed in on our signing sheet. The procedure for when the cases are called, if you are the appellant, you'll come forward and you'll stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone is up here, we'll get you all sworn in. And the appellant will be given the opportunity to go first. Let us know what exactly is being presented, what the issues are that are involved, answer any questions from the board, present any witnesses, submit any documents and the like that they would like the board to consider as part of their presentation. Once they've concluded, we'll next turn to the opposition, if any, and they'll be given the opportunity to present their side of things. Once they've concluded, we'll return back to the appellant, who will be given the opportunity to respond to anything brought up by the opposition and to offer a closing statement. We're not going to be going back and forth, unnecessarily delaying things. You'll note that there are a number of folks present today for hearings, and we don't want to keep people delayed longer than is necessary. We'll generally be calling the cases in the order in which they appear on our docket after we first address some preliminary matters. We have a couple of cases which are being postponed for one reason or another. The first case which is postponed is 2015-100, 1807 through 09 Barclay Street. That case is being postponed until July the 14th, 2015. So if you're here in reference to that case will not be heard today. And 2015-13, 200 East University Parkway. Mr. Woolman and Councilwoman, if you both could approach. You'll note that, well, as you know, I think that as we had discussed off the record, For your case, we won't be able to have a quorum to hear it, and we can likely get your case back in front of us 2 weeks from now when the board reconvenes, and we should have a quorum at that time. So I guess if you can coordinate with your witnesses and the like, that should be fine.
Thank you, Mr. Chairman.
Okay, thank you. Take care. All right, the next cases that we'll address are cases on our consent agenda. And the consent agenda consists of cases for which the zoning board staff has reviewed our files on these matters and we have determined that there is sufficient information in the record to approve these appeals. We're going to call all of the consent cases as a group, and if you can come up as I read off the cases, the first person in line, if you can, well, the first case that's called, if you can stand there, everyone else will line up behind them. Once everyone's up here, we'll get you all sworn in, and you'll be given the opportunity at that point to offer any supplemental information if you so choose. First case on our consent agenda is 2015-152, 1801 Light Street, Lisa Junker. The next case is 2015-154, 217 South Chester Street, Jim Seymour. Next will be 2015-155, 1104 East Fort Avenue, Matthew Lazinski. After that is the 2015-156, 1450 Decatur Street, AVK LLC, care of Jagtar Radhawa. Next will be 2015-159, 110 South Chapel Street, Baltimore's Distinctive Homes LLC, care of Kurt Schiller. Next will be 2015-160, 333 West Ostend Street, AB Associates, care of Nate Predel. Next is going to be 2015-162, 1604 West North Avenue, Dennis Wright. After that will be 2015-165, 414 South Durham Street, Joseph Lasak. 2015-166, 1238 Riverside Avenue, Stephen and Andrea Stroecker. Next will be 2015-167, 610 South Robinson Street, Duck Shores, Maryland LLC, care of Rick Vonador. Next will be 2015-169, 3828 Foster Avenue, Rick Vonador. And 2015-171, 38 through 40 East 25th Street, Ben Frederick. And finally, 2015-172, 1838 Light Street, Joseph Brandley. Okay. If you can all raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, first case is 2015-152, 1801 Light Street, Lisa Junker. Good afternoon, Ms. Junker. We have this as an application to subdivide the existing lot into two lots, 1801 Light Street to be known as 1800 Westvale Place, to retain a grocery store and one dwelling unit on 1801 Light, and a detached single-family in the premises to be known as 1801 Westfall Street. Is that correct?
1800.
No, it's backwards.
Okay.
1801 Light Street is to be subdivided in its entirety with one single-family dwelling detached to be known as 1800 Westbow,
1800 Westfall?
correct?
Okay.
And the remaining mixed-use first-floor commercial with the single-family dwelling above
Mm-hmm.
will remain known as 1801 Light Street.
Okay. Thank you for the correction. And Mr. Friends for the planning department.
Thank you.
The Department of Planning recommends approval of this appeal, subject to the condition that the subdivision of the property receives approval from the Planning Commission. Thank you.
Thank you. And Ms. Junker, does your client agree to the condition offered by the planning department?
Yes.
Okay. And is there anything further you'd like to add to some of the record?
No, thank you.
Okay. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal.
Thank you very much.
You're welcome. Next, 2015-154, 217 South Chester Street, Jim Seymour.
Yes, sir.
Afternoon, you're Mr. Seymour?
Yes, sir.
All right, Mr. Seymour, we have this as an application to construct a three-story rear addition on the premise. Is that correct? All right. And Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Seymour, did you have anything further you'd like to add to supplement the record?
Yes, sir.
Okay. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal.
Thank you, sir.
You're welcome. Next, 2015-155, 1104 East Fort Avenue, Matthew Lazinski.
Yes, sir.
Afternoon, sir. We have this as an application to construct a second-floor rear overhanging addition. Is that correct?
Yes.
And Mr. French? anything
Planning
to
Department has no comment on this application. Thank you.
Thank you. And Mr. Lazinski, anything further you'd like to add to something on the record?
No, sir.
All right. Zoning board staff, having previously reviewed application, we determined that there is sufficient information to approve your appeal.
Thank you.
Thank you. Good luck. Next, 2015-156, 1450 Decatur Street, AVK LLC, care of Jagtar Radhawa. Afternoon, sir. We have this as an application to construct a two-story rear addition with second-floor rear deck accessing rooftop deck. Is that correct? Yes. All right. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And sir, is there anything further you'd like to add to something on the record? All right. Zoning board staff, having previously reviewed the application, we've determined that there is sufficient information to approve your appeal. Thank you. Good luck. Next is 2015-159, 110 South Chapel Street, Baltimore's Distinctive Homes LLC, care of Kurt Schiller. Afternoon, sir. We have this an application to construct a first floor and second floor infill additions on the premises. Is that correct? Correct. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Schiller, anything further you'd like to add to some of the record?
I just have some additional signatures if you would have interest in that, people supporting the project.
Okay, we will add these to our record. Anything further? All right. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thanks. Good luck. Next, 2015-160, 33 West Ostin Street, AB Associates, care of Nate Predel, or Al Berry. Afternoon, Mr. Berry. We have this as an application to use the entire premises as office, business, and professional. Is that correct? Mr. French, for the planning department.
Planning Department has no objection to this application. Thank you.
Thank you. And Mr. Berry, anything further you'd like to add to some of the record? All right. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Good luck. Next, 2015-162, 1604 West North Avenue, Dennis Wright.
Mr. Chairman, I'm going to recuse myself from this matter.
All right. Mr. Bonaventure's recusal is noted. And Mr. Wright? We have this as application to use the entire premises as a multi-purpose neighborhood center to include computer lab and youth violence prevention center. Is that correct? Okay. Mr. French, for the planning department.
Planning Department recommends approval of this application. Thank you.
Thank you. And Mr. Wright, anything further you would like to add to supplement the record? Okay. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal. Thanks. Good luck. Next, 2015-165, 414 South Durham Street, Joseph Laschek. Thanks for saving me on that. All right, Mr. Laschek, we have this as an application to construct a first floor rear deck on the premise. Is that correct?
The document is incorrect. It's actually on the second floor.
Okay. I thought that was a little bit odd.
Yeah.
All right, and with that correction, anything else?
No, sir.
Okay. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Laschek, anything further you'd like to add to supplement the record?
Just simply a letter from my next door neighbor recommending that we allow the
Okay. Thanks. Well, this is a letter received from Suzanne Bailey. Just briefly summarizing the last sentence, I completely support this request by the Lazcheks and trust that you will also. Thank you. Anything further? Okay. Zoning board staff, having previously reviewed the application, we've determined that there is sufficient information to approve your appeal.
Thank you. Y'all have a nice
Thanks.
day.
Good luck. Take care. Next, 2015-166, 1238 Riverside Avenue, Stephen and Andrea Strohacker. Afternoon, Mr. Strohacker. We have this an application to construct a second floor rear deck on the premises. Is that correct? Mr. French, anything with the planning department?
Thank you.
Thank you. And Mr. Strohacker, anything further you'd like to add to something? Okay. Zoning board staff, having previously reviewed the application, we've determined that there is sufficient information to approve your appeal. Thanks. Good luck. Next, 2015-167, 610 South Robinson Street, Duck Shores, Maryland LLC, care of Rick Vonador. Okay, and Mr. Vonador, we have this as an application to construct a two-story rear addition with a rooftop deck. Is that correct?
That's correct.
Mr. French, anything for the planning department? Okay, and Mr. Vornador, anything further you would like to add to something like that? Okay. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal. I'm guessing you're here on the next one, which is 2015-169, 3828 Foster Avenue, Jeff Vornador appearing. And we have this as an application to construct a two-story rear addition with a rooftop deck. Is that correct? Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
And Mr. Vonador, was there anything further you would like to add to supplement the record?
No, sir.
Okay. I had that we had some conditions on this one, something? No? Okay. All right. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thanks. All right. Next, 2015-171, 38 through 40 East 25th Street, Ben Frederick.
That's me.
Afternoon, sir.
Good afternoon.
We have this an application to house 5 dwelling units on the premises and a first floor commercial. Is that correct?
Yes, that's correct.
All right. Mr. French, anything from the planning department?
Application. Thank you.
Thank you. And Mr. Frederick, anything further you would like to add to supplement the record?
Nothing further.
Okay. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thanks. And last, 2015-172, 1838 Light Street, Joseph Brandley.
That's me.
Afternoon, sir. We have this as an application to construct a second floor rear addition and a rooftop deck accessed from a stair penthouse. Is that correct?
Correct.
All right. Mr. French, anything from the planning department?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Brandley, anything further you would like to add to supplement the record? Okay. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal.
Thank you.
Thanks. Good luck. Okay. The remainder of our docket includes cases for which opposition is signed in. And frequently we found that opposition is the result of either a lack of communication or a miscommunication between the parties. And frequently it can be useful to offer the parties an opportunity to have a dialogue for the applicant to speak with the opposition, let them know what the plans are, the opposition to ask any questions, and generally for the parties to be able to seek out a resolution to their dispute amongst themselves. Obviously, if opposing sides to an issue approach the board and ask the board to resolve it, one of those two sides is bound to go away dissatisfied with the result. And this is your opportunity to avoid that unhappy fate. I'm going to call off the cases where opposition is signed in. I'll just ask you to stand where you are. We'll ask if there's been any discussion between the parties to date, or if the parties would like to have a discussion and try to see if they can get things worked out. You're certainly not obliged to take that opportunity to have a discussion, but we certainly do encourage and appreciate it. First case for opposition is signed in is 2014-440, 3305 East Fayette Street, Jason Vittori. Okay. And, okay. And folks, has there been an opportunity to have a discussion?
Yes, very much so.
Okay. Any prospect for a resolution? Okay. Have a seat. We'll call you in turn. Next up is 2015-157, 6327 Green Meadow Parkway, Lisa Junker. Okay, folks, have you had a discussion at all? Okay.
Actually, I haven't spoken. The notification of opposition actually just presented itself to the property owner last evening, so I would like the opportunity to have conversation with that man.
Sure, sure. Okay. Have a talk and see if you can get something worked out. If not, then we'll hear the case. Next is 2015-158, 1175 Sargent Street. I'm not going to try this name first. And who are the folks on that case? All right. And have you folks had an opportunity to have a dialogue? All right. Would you like to have one? Okay. Just step right outside and see if you can get something worked out. All right. First case, we'll call 2014-440, 3305 East Fayette Street, Jason Vittori. Okay. Mr. Vittori?
Jason Vittori with Smith, Gilday, and Schmidt on behalf of the appellant petitioner.
Okay. And you counsel for the opposition?
Well, I'm Dave Leidensberger. I'm the former president and current safety chair of the Patterson Park Neighborhood Association. I'm an active spokesperson for the neighbors today. Essentially, at the end of their term.
Okay. All right. We have this as an application to use the entire premises as garages other than accessory for storage, repair, and servicing of motor vehicles not over 1.5 ton capacity, including body repair, painting, and engine rebuilding. Is that correct?
This is the way that we were told we should caption it in our request
Okay.
for relief. As I'll get into more, there has previously been approvals for this site to get a conditional use for a service garage. Those were done on an individual basis. It's not entirely clear from those decisions. There have been complaints from the community with respect to this service garage, as you'll hear later on. And our position is, Jeff Veal indicated to us that he would like my client to be the one that's responsible for all the folks there because of some language barriers and different issues. So instead of these individuals having come in the past
Gotcha.
for individual respective garages within a larger site, that the owner would be in charge of it, because ultimately, as you'll hear, the use itself isn't something that the tenants could get an approval here, relocate to some other place with that approval. As you know, with conditional uses, it has to do with the particulars of the land there and the use at that site. So
That's
it's kind of a housekeeping item in our opinion about what we're doing here, as opposed to a code enforcement matter, I think, which you're ultimately going to see this kind of turn into as to what has happened and what's going on, and or a request for a new conditional use approval. But
Okay. All right. If all those intending to give testimony can stand and raise their hands to be sworn.
Raise your right hands, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Okay. Do we have staff?
Yes. First, we have letters from the Patterson Park Neighborhood Association and the Baltimore Highland Neighborhood Association. They write that these businesses have been in direct violation of zoning and other laws for many years, and these garages are a consistent blight for our neighborhood. They go on to list over a dozen violation notices. In addition to operating illegally, there is no parking, so vehicles are parked on the sidewalks and in the middle of the street as they await repair, blocking traffic right away on a consistent basis. Vehicles that are clearly non-functioning or often missing wheels and headlights are regularly parked on the sidewalk in front of the businesses. It is our understanding that the garages lack proper ventilation, posing a potential health and safety threat to both employees and customers. Additionally, residents have noticed dumped oil on the street, car parts that have been improperly disposed of. In fact, the Maryland Department of Environment opened an official investigation in December of 2013 of the waste and oil disposal practices of the businesses in the area, as well as the air quality violations stemming from the unfiltered stripping and painting of vehicles. These garages are consistently surrounded by garbage, bulk trash like mattresses and litter. For all of these reasons, and for all of the reasons that the Patterson Park Neighborhood Association has stated in their letter, the accompanying documents that Baltimore Highland Neighborhood Association respectfully requests that the BMZA deny the application for automotive repair conditional use. We have received letters from residents. They write, I have passed by these properties and noticed the detrimental effect they have on the community. Sidewalks are filled with leaking, half-broken cars, piles of tires on the sidewalk, open garage doors full of industrial parts. This hardly creates an atmosphere of a healthy residential community. Most surprising to me, these garages are not even zoned to be there. I had assumed that they possessed all the required permission to be there, but in fact, they are very openly ignoring the law. Let's see, which would encourage others to ignore the law in a similar manner. This resident, BDC, supports small businesses, however, not due to the detriment of the surrounding community, and therefore would respectfully request that this be taken into consideration when making a ruling. Our resident writes, we are on a small, limited budget. Sometimes we wake up and have flats. I cannot afford to tow far out. It makes it easier for me to just take it up the block. We also feel that leaving these shops open gives people a chance to work in these hard economic times. Please have pity on the poor, hardworking folks. Let them have opportunities. If it is an environmental issue, please refer them to get a grant or have the neighborhood association help with these changes. This is a positive letter in favor. It has been brought to my attention that there is a small but vocal group of neighbors that are against an appeal for rezoning by the owner of the garages located in the 3300 block of East Fayette Street. Their argument against the current use states that these garages are a blight on the community and create a safety hazard. I am a new neighbor, having moved a block from these garages just under a year ago from Washington, D.C. I do not see what some of my neighbors are calling blight. I see a thriving strip of small shops and shop owners, amazingly hand-painted signs, and interesting people living and working hard. It is a micro-community of auto workers, which I feel should be supported. Many of these shops owners are new and immigrants. They take care of their spaces and offer a much-needed service. I walk and drive down the streets every day and have never once noticed or felt concern for my personal safety. Let's see. This writer writes, I would like to go on the record to say I support the multi-use and rezoning of said structure on Esther Place. These businesses will currently operating at a great area in a great area to provide employment and needed services for the community. We have a letter from Councilman Kraft. He has received letters from the associations. It's not clear. He supports the position taken by the associations. And then we have planning's report.
Thank you. Planning Department reviewed this application. Just by way of reference, the Esther Place that was referred to is on its south side, not zone commercial, zone residential. It is zone B3 on the north side, closer to Fayette Street. And part of the problem with this property in general is that a lot of people are not aware, including the tenants, of this important division. As we've heard cases, I believe, in the past few years of people who wanted to do service garages on the south side of Esther Place. That said, the department also noticed that there have been incidents where there has been use of both the sidewalk on the southern curb lane of Fayette Street to work on vehicles being serviced, and there does not appear to have been minor privilege permits authorizing these obstructions. Regardless, the department recommends that approval of this appeal, if granted, be subject to these conditions in addition to conditions which the board may establish. There will be no parking, staging, or storing of vehicles on public rights-of-way. There will be no parking or storage of unlicensed vehicles on the property. All work must be performed indoors. All materials, parts, and equipment related to the use will be stored indoors. The internal area used for temporary storing of vehicles will be adequately screened by an opaque fence, wall, or gate. And if a dumpster is used to collect waste and trash related to the use, the dumpster will be placed either inside the existing building or at the rear of the structure on Fayette Street within a masonry enclosure having a solid lockable wooden gate. Thank you.
Thank you. Okay, Mr. Vittori, the conditions offered by the planning department, is your client amenable to those?
I spoke with my client, he is amenable to them, yes.
Okay. All right. Why don't you tell us what we're here on?
Okay, as I previously alluded to, ultimately, what led to this request for relief was in fact a citation. For I think a lot of the points that were made there, that there is, I think if you have the pictures, and I'll put some in evidence through my witnesses, if need be, and I'm sure the protestants will also put in some pictures as well, showing the area. It's an alleyway with a bunch of storage, service garages. They kind of look like a self-storage facility along the way. The garages are not very large. This is an older structure.
Mm-hmm.
And ultimately, it has had approval to be operated as a service garage for a number of years.
Mm-hmm.
With that in mind, these people are trying to get as many cars in. They did do some lifting up of vehicles and some work on cars out in the right-of-way, which would in fact require a minor privilege. They've been advised that they can't do that. I think Mr. Smelkinson, as you'll hear, is going to tell you that he is now in charge and making sure that they understand that if they don't abide by these rules, he is going to have them removed from their tenancy, because otherwise they face a threat of another proceeding that could revoke this conditional use. That's not what we're here for. We're not here for that proceeding. We're here to, I think, do the housekeeping of getting this in his name so that he receives a notice, so that the city doesn't have to go after each of the individual tenants and then run through a much less efficient process by doing so.
Okay.
And we're going to put on a case for the conditional use as well, just out of an abundance of caution if you don't agree with that legal theory.
A couple of things. First, I note that both sides do have a number of witnesses, and I think that what we found can be useful when we have those kind of situations is, it's a situation that kind of lends itself to a lot of duplication, just simply because you have a lot of witnesses who share the same viewpoints and are really just being called for the same purpose. So to the extent that you can deal with their testimony by way of proffers, so if you're going to have one person testify, and then you could say, if also called to testify so-and-so, these people would similarly say have the same comments as this other person. I think that would be a much more efficient way for us to go forward. Second thing is, I guess is a question more for the opposition, is, and there's two questions. I guess you heard the conditions offered by the planning department, were we to approve the use with those conditions offered by the planning department, so how far would that go towards addressing your concerns? And second of all, do you share the same view of the proceedings as far as that what the board is being called on to do is to really recognize these, what have been individually approved uses for all the different spaces in the past, now being approved just simply for the entire premises instead of on a one-by-one basis?
So just going down the list, we can definitely limit the number of witnesses who will testify. There is a lot of duplicative testimony, so I can definitely do that. Regarding the planning department's recommendations, we actually would be satisfied if we had any confidence at all that those would be complied with, but I have no confidence that those would be complied with for several reasons. One, all of the issues that were raised by the planning department, I raised with Mr. Smilkinson, the owner, years ago in a private meeting between he and I when I was president of a neighborhood association, that those things needed to be done. At the time, he disputed whether or not he was actually working in the public right-of-way. He disputed what was and wasn't the sidewalk and just outright refused to make those very improvements. Once this hearing was scheduled back in December, the planning department at that time issued those recommendations. Mr. Smilkinson was given those recommendations. I was given those recommendations. Mr. Smilkinson, by way of email, which I'll show you in a bit, promised me that he would make that he had showed those to his tenants and that they were going to make those changes immediately. That was December. Nothing has changed. You'll see photos taken this morning. You'll see photos taken yesterday that are the exact same problems demonstrating the really horrific conditions that are over there on those garages on a daily basis, that residents, that children have to walk through, children play in those streets. And I'll let the evidence speak for itself when it comes up, but I have absolutely zero confidence that if the board would grant that conditional use, that any of those recommendations would ever be complied with. We would be back here for hearing after hearing trying to enforce it. So I ask you to not grant the conditional use so that we don't have to come back for another enforcement. It doesn't make any sense. And these poor folks have been dealing with this for so many years. To ask them to have to keep coming back to the hearing room to deal with this issue, which has been ongoing for so long, I think is unfair. And so, and then to the last point, what we're here for today, my understanding is that there are not conditional uses for these businesses over there. My understanding is that they're conducting engine repair, automotive repair, car spraying, tire repair, tire changing, all without uses. Now, if they have documents showing that these individual properties have those uses, that might be a different story. But as the planning department just pointed out, the south side of Esther Place is residential. That's what all this is about. This hearing is not about Fayette Street. Fayette Street has its own problems, and maybe someday we'll be back here for all the issues on Fayette Street. As the planning department pointed out, there's work taking place on the sidewalk and in the middle of the street on Fayette Street. But the only thing that faces Fayette Street are businesses over there. On Esther Place, which is on the other side of Fayette, it's residences. Residences have to look into cars being repaired in the middle of the street, on the sidewalk, on a daily basis. Oil, every other kind of engine, lubricant, fluid is all over the ground, all over that area. And so my understanding is that is all absolutely without permission of this board. And that's why we're here today, to get that permission and for us to oppose it.
Okay. A couple of things. First, as far as the geographic orientation of the property here.
I have some maps if you'd like to see.
We actually have a couple.
Okay.
And I see that this property fronts on the south side of East Fayette Street and the north side of Esther Place. And
Yes, that's correct.
as I look at our zoning map, I see that the line between the R8 and the B32 zone runs down the middle of Esther Place such that as the planning department said, such that the south side of Esther Place is zoned R8, but the north side of the street is zoned B32. So are you saying that work is going on the other side of the street?
Oh,
from
yes.
Can we mark a joint exhibit, just to
Sure.
kind of make sure we're all on the same?
Yeah,
Are you
that's fine
with
with
this?
I'm fine with that.
wants to do, but
Yes, I am most definitely saying that. I am most definitely saying that there is work taking place on the other side, belonging to the businesses on the north side of, businesses on the north side of Esther are conducting car repair on the south side of Esther, in the middle of the street, in the sidewalk, on a daily basis.
Okay. And that kind of dovetails into the next point I'm just going to make insofar as the conditions offered by the planning department. I hear you as far as your lack of faith in the applicant's ability to conform the activities of their tenants or of I guess, his or its tenants. Its tenants formally to the conditions that are being offered by the planning department, but I think that those conditions are kind of important. And they're important as I see them, or potentially important anyway, in that it would give you the leverage that you don't now have. In that if there were an approval from the board that was contingent upon compliance with those conditions offered by the planning department, the matter wouldn't be a matter of continual hearings, but rather it would be a matter of enforcement through the zoning administrator's office, such that if residents observed that those conditions weren't being complied with, provided you got the zoning administrator's office out to confirm that non-compliance, that would generate a violation and would therefore put the license at risk. And if there was, certainly if you built up a record of compliance over time, that would be a pretty damning record at that point. And the applicant or slash owner would be looking at a very daunting situation possibly. So yeah, I think that the conditions offered by the planning department are a important avenue of enforcement that's out there for the community that holds the potential prospect of enhancing your hand. So I just
May I-
wanted to make sure that
Yes.
that was understood.
2 points on that. Regarding leverage, I think we already have significant leverage. They've been cited 3 times in the last year, on 3 different occasions. I believe March of last year, July, and then again this year. So we already have the enforcement mechanism from the zoning department to go out there and give them the citations because they've been doing this work. As you'll see, the citations, they've been doing this work without the permits that they've needed, and yet they've continued to do it. They've been told that it's illegal multiple times, and they get cited again and again and again for the same thing. That's why we don't want to see this approval, so that we don't have to deal with it again. So I think we have that leverage already. We've been trying to use it, and that's why we're here today. Secondly, on that point, the board should not reward this owner with his bad behavior for years and years and years. Yes, it would give, potentially us another enforcement mechanism, but it would also be a win for this owner who has completely neglected the area, completely neglected, and again, you'll see that. Lastly, on those conditions, I didn't say it before, but we're going to point out in our testimony, it is going to be literally impossible for them to comply with some of those conditions. Some of those conditions cannot be physically complied with, given the structures that exist in that area. They cannot be complied with.
I would also add quickly that there are provisions in the zoning code for Baltimore City that provide for revocation of a conditional use approval should somebody ultimately have an issue with becoming compliant with these conditions. I've been brought on this matter to explain to my client, which I have, and he is, I understand it, has explained to his tenants. And, obviously they're working diligently towards that end. They plan on, as you'll hear, if we don't proffer, I think we could get through the testimony maybe quicker without proffer, because I'll only call a limited number of these folks as witnesses. But I think you'll get the gist that ultimately, there is a process for all this. One is have conditional use approval. We believe we have that already. I think buttoning down the situation of this is, he, the property owner, stands the most to lose. Not that the tenants don't stand a lot to lose as well, being displaced from their place of employment and the folks that they employ. And the last thing we want to do is run those guys out. We're certainly trying to explain it to them as clearly as we can, but ultimately I think there is a process in place, and that process affords, this board, I think, and, the zoning administrator an opportunity to revoke the conditional use approval should this situation not improve itself.
Okay. Why don't you call your first
Sure. Call Dan Smelkinson.
May I use this ledge?
witness? Yes, please.
Okay.
Just make sure you watch out for the
Yeah,
microphone.
okay, all right, thank you very much, I apologize.
Same goes for you, Mr. Vittori. I know those files can get a little bit heavy.
Thank you, yes.
Didn't notice.
That's fine.
Okay, we'll make sure.
Could you please introduce yourself to
My
the,
name is Daniel Smelkinson, and I've been the owner since 2006.
Mr. Smelkinson, could you please talk into this microphone? We'll both get on the side of it. And then also, just the kind of ground rules of question asking and answering. If you could wait for me to finish my question. I know you know what your name is and you know what the conversation is going to be like, but ultimately, we're not having a conversation.
Spell last name.
I'm going to ask you how to spell your last name. You're going to wait for me to ask you, and then you're going to answer. Okay? How do you spell your last name?
Smelkinson.
Thank you. Are you the principal with 3305 East Fayette Street?
Yes,
And is 3305 East Fayette Street LLC the owner of the property?
yes,
Mark, what's, as petitioner, as appellant's exhibit 1, an SDAT printout. I'll show you a document
Yeah.
just quickly,
Thank you.
establishing the ownership.
Okay.
Can you tell me when you purchased the property as an authorized representative of 3305 East Fayette LLC?
I think it was 2006. Yeah.
Thanks. And does the subject property have any improvements on it?
Yes,
Do you guys have a copy of the plan marked or in the file that goes into the record, or should I mark one as exhibit? I'm going to mark a copy of the plan that was filed with the request as petitioner's exhibit 2. Is this a plan that you had prepared for this request for zoning relief?
I did have my engineer prepare that, yes.
And who was your engineer?
Josh Nicodemus.
And can you kind of briefly go through what uses take place on this property, how the property is laid out, and the direction arrows as well, what the north side is, east side?
Okay, the north side faces the Royal Farms, and the south side is the alley.
Sorry to interrupt.
Okay,
The Royal Farms is towards North Highland Street?
yes. The east side is where Esther Place is, and the west side is Fayette Street.
That's going to be what it is. I mean, typically, your east roads run east and west, correct? And your north roads run north and south? Is that my understanding? That is my understanding.
I just, it's true, but I know that that's facing north, and that's facing south, and that's facing east, and that's facing west, so
That you pointed out as Esther Place being east, correct?
it faces east.
Okay.
It's on the east side of the property. but
And that's on this exhibit where the little kind of cross-hatched areas that are marked 1 through 13 are located, correct?
Correct.
Okay.
If I
And
can
what takes
interrupt
place
for
in
a
it?
second? We've got a aerial that might help. This, I believe, is Fayette.
Yes, that's, okay, so that's Royal Farms right there, and then this is the Esther,
I believe this is, so right here at the corner of Fayette and Highland.
Correct.
There is what appears to be a gas station.
right.
Correct.
And I think that to the rear of that property is Esther.
Right, that's it, right.
Where
And,
the 13 garages are.
and on this side where the arrow is, I believe that is Fayette Street.
Correct.
Correct,
You
okay.
mark this as an exhibit, or that's part of your?
We have all of these, but that'll orient you on the map that you have there.
Sure.
So that you can tell where everything is.
All right. Do you know approximately when these improvements were built?
Approximately, I'd say 1998.
98, okay. And prior to your purchase of this property in approximately 2006, what due diligence or investigation do you do as to the use being permitted here?
Sure, I think my title agent checked out the zoning, and my real estate agent checked out the use permits, and everything checked out that there was the proper zoning and the proper use permits were already filed for and already approved by the city at that time.
And the service garage use was taking place when you took ownership of the property?
Yes.
And were you aware of any complaints or anything taking place or any limitations as far as the use that was taking place out in the right-of-way as you've now come to know it is?
No, there were no complaints. Apparently, from my understanding, it had been operated in that manner for the last 40 years, and there had never been a complaint. I had never received a complaint until about 3 years ago.
Present you with Exhibit 3 for the applicant. Does this accurately reflect, in your opinion, what the alleyway looks like on Esther Place?
It does.
I agree with this 100%.
This is off of Google Maps. And to the left is his side of the property. To the right is, I thought, what was explained and proper as a bunch of residences, but as you can see, it's a bunch of garages. So I just wanted to.
Well, just to be clear, are they garages attached to residences?
Could you, on the opposite side of the street from the service garages, there are garages. Are those garages attached to residences?
No, there's about 180 garages there, and they're not attached. It's about, no, there's no.
What's on the other side of the garage?
On behind the garages, so to speak,
Oh.
that we're talking about?
Well, there's about 8 rows of garages. Then after that, after about maybe 200 yards, well, maybe 150 yards, there are residences.
So these garages are rentals, I'm assuming?
They're storage rentals. They're not zoned for auto repair at all.
No, I understand that.
And I think that's if you don't mind me saying, I think part of the problem is that the confusion here is that people are confusing the use of those garages, which are for storage, and the use of my garages, which are for auto repair. So they think that because those garages over there are not approved for auto repair, they think that my garages are not, but in fact, my garages are approved for auto repair. And that lends a lot of confusion, and the reason why it was said here at this hearing that my garages are quote-unquote illegal, which they're really not. They're not illegal at all. They're perfectly legal.
You've heard the proffer from opposing counsel, representative for e-protestants, that they've been working with you and you haven't essentially made any effort whatsoever. Do you feel as if that's true?
Quite the opposite.
Can you explain why you don't feel that's true?
I mean, I'm down, I go to these garages almost on a daily basis, working with my tenants. As you can see, I'm 100%, I believe I'm 100% supported by all my tenants, and in fact, they showed up today at the hearing, represented here, and they can testify if they want to that I'm an active owner. I work with them doing, I think, problem solving on a weekly basis. I try to keep the place, running smoothly, and it's quite the opposite. I'm not a so-called quote-unquote absentee landlord or anything of that nature. I take the neighbors' complaints seriously, and I try to make it better to the best of my ability, knowing that these are auto repair garages, and that if they don't want me there, there's nothing I can do to change it from an auto repair and wave a magic wand and turn it into something else. They are auto repair garages. They are legal, and frankly, other than that, I can sympathize maybe somewhat with the neighbors' complaints, but for them to expect me to do what they want, which is not to exist, is just not possible. I do exist, and plan to exist there for a long time. I don't. And we would, having said that, I do expect that we will, I will continue to run the property sufficiently and in the best way possible to consider everybody's rights and responsibilities there, including my tenants and the neighbors. And keep in mind now that these properties have been there, I think, for 100 years, okay? And to now suddenly say that we're not legal when the whole neighborhood is full of auto repair garages. One of the problems I have was that I get blamed for all the other auto repairs that aren't my garages, that are owned by other people, that perform auto repair work. For example, a car could be in front of their property and I get blamed for it. I don't think that's fair. If it's their property, if it's,
I'm going to object to this narrative. There's no question. So,
so I'll just conclude by saying, if it is, if I do something wrong, I'll take responsibility for it. But I don't want to get blamed for the entire 4-square block area, which is all auto repair, up and down the street. And that's it.
Have you talked to your tenants to explain to them the serious ramifications of if they do violate these conditions that the planning department has sought to impose on your use, that they in fact will be, told to vacate the premises and no longer be able to operate there?
I did talk to them many times.
So how would you enforce that? I mean, do you have a lease with your tenants?
Of course.
How, if your tenant decide that they don't want to comply, you give them a notice that they're in violation and they either ignore you or just don't go. What do you do? How long does it take to get enforcement?
Of course, if they, yeah, you asked about, okay, first of all, they have to comply because it's the law. I mean, otherwise they'll get a citation from which they've received before and they've paid. So they know the rule, they know the law, and they know the penalty for not abiding. They come here today, a lot of them, with me because.
I guess my question is,
Yeah.
what's within your control?
Oh, I could easily just, if they violate it, they repeatedly violate it, then they're violating the lease.
Right, and I keep going to, so how does how does it, under your lease, how does that work? What's the time frame if someone violates a lease?
They have 30 days to, if I give them a notice to vacate, or I'm sorry, notice, I can cancel a lease, and within 30 days, or I think it's 60 days in Baltimore City, they have to vacate the property.
Okay. And can you explain a little bit about some of your tenants, kind of who they are, their background?
Sure. All of my tenants have been there for a long time, first of all, and when they come, they never leave because they realize that it's a great location. There aren't a lot of places in Baltimore City you can have auto repair anymore. It helps the residents, as you proffered in those letters that were sent in, which, by the way, I didn't even know those were going to be read today. People did that on their own, sent letters in, supporting the garages. We have a great little community there. There's no crime in the area. We're pretty much self-policed. You don't see any crime down there. There's no drug dealing down there. There's no prostitution. It's an area that's known as an area of Baltimore City where one can come and get their car repaired for a reasonable price and get reasonable work done, deal directly with the owner. We're not a big national chain. You can get almost anything done there, from as simple as getting your oil changed to having a major transmission overhaul. So I think it's an asset to the city. There's no question about it. It's been there a long time. They are amongst a bunch of other auto repair garages. It's simply zoned for that. It's meant to be there. They have to abide by the rules. I'm going to
object and
arguing
move to
with
strike
any
the
of that.
answer as non-responsive. He was asked who his tenants are, and now we're talking about what is going on in the garages. This is meandering.
I hear you. I'm going to overrule the objection for the reason that although the board is a quasi-judicial board and we do follow the rules of evidence to some extent, those are loosely applied. But I would, for the sake of the fact that we've got a lot of cases, yours is the first,
Okay.
try to keep your answers confined to the question that's before you. Well, I actually have a question here. You've owned the property since 2006. And I think, according to the SDAT record, it was December 2006 that the property was purchased. Have you yourself been a part of any prior zoning appeal concerning this property? Or these properties?
No.
Okay. Are you aware of any zoning cases previously being brought concerning any of these properties?
I believe that there was a zoning case. This is just hearsay. The prior owner, Mr. Zappardino, he's now deceased. He told me that he had the entire property when he owned it years ago. and this is all just, what he told me, I don't know if it's relevant, but when he originally pieced it off and sold that to the Royal Farms and got the rest, the city to approve to have the rest zoned, because they were garages at the time, zoned for auto repair, and yet, because they were similar zoned to the other ones that were across the street.
Okay, and what we've got in our zoning history is, since you mentioned Mr. Zappardino, a case in April of 1989, case number 89-117, 1L Zappardino, there was an application to construct a one-story auto repair garage. That was disapproved. In 2003, there was an appeal by an R. Kanda, the case number 03-220. That was an appeal to use a portion of the premises for auto repair, including body repair. That appeal was approved conditionally in August 2003. In July 2006, case number 06-598, and M. Barrientos received an approval to use a portion of the premises for auto repair. Again, I don't know which addresses this corresponds to, as there are a number here, but these were the prior cases. 07-283, and A. Chillette received an approval to use a portion of the premises. This is for 3314 Esther Place for sale and repair of new and used tires in conjunction with auto repair. That was approved in April of 07. And in August of 07, case number 07-830, A. Chillette received a approval to use portion known as 3314 Esther Place, spaces D, E, and F for sales and repairs of used tires in conjunction with auto repairs. That was in October of 2007. And then in 2012, case number 11-523, and F. Osorio they filed an appeal to use what was known as 3306 Esther Place for sales of new and used tires and auto repairs. That appeal was dismissed. It may have been a no-show. But those are the prior cases that we have. And you weren't a part of any of those cases, I guess, any of those ones following December 06?
Other than being, as the owner of the property, I didn't take part in the individuals.
Sure. Did you have knowledge of them at all? Did you know that cases were being filed in like?
I had vague knowledge because they asked me copies of the lease, and they wanted to show up and have the lease with them, and that was part of the procedure.
Okay, all right.
Can I ask a clarifying question about what you just presented?
Sure.
Do we know whether or not any of the addresses are associated with the 3305 Fayette Street address that we're here for today?
Well, what we have.
Is it the same property? I mean, those sound like different addresses to me.
Well, it's a little bit unclear because although we have the premises address as 3305 East Fayette Street, what we have is the proposal is to use entire premises 3305 through 3321 East Fayette Street, including the portions known as 3302 and 3320 Esther Place. So I'm guessing that each of the bays may have its own separate address on the front end. That's correct.
Okay,
So
I understand.
each of those appeals would apply to some portion of the premises.
I understand. Thank you very much.
You're going to get caught, just editorialize for a minute. Ultimately, you go to the zoning administrative office, they may say something that doesn't come to this level and how all that works out and what they did. It ends up before you just decide the cases that come, particularly if they came on the consent docket and they got approved.
That's right.
Ultimately, I think, some of those cases dealt with particular provisions where they were adding an accessory use.
I think that's correct.
Well, I don't think we're really talking about accessory uses other than that we could add a few things about tire sales, because that certainly takes place on some of these uses. I think that, that would be an appropriate use. But ultimately, without any further proof that 3305 constitutes something less than the entire property, and these decisions speak for themselves, and approval has been granted. Those that don't have some additional, breaking down of the uses, but I think there's at least one that says 3305, the entire
think
property.
that'd be correct.
I'm sorry, there was one in that list that said 3305, the entire property? I did not see that. I heard one with no address. I heard 3314 twice. I heard 3306.
There was one, the entire premises.
Yeah, let me find it.
No, you didn't say three.
No, I
No,
said,
but there is a use and occupancy on 3305 in addition to all these others that, in fact, all those addresses, the names that the people, the applicants are all my tenants, so,
Yeah, and just to clarify, the ones that I read off were all to use a portion of the premises for some particular use. The only one that applied to the entire premises, or at least, didn't have any kind of clarifying statement, but it applied to a portion, was the first one. Case number 89-117, case filed by Mr. Zappardino to construct a one-story auto repair garage. Without knowing particulars of that case, I can't be sure, but it sounds like he may have wanted to construct one all-encompassing garage on the premises, demolishing the individual garages. That may have been disproved, but that's kind of not clear from the record that we have.
So just a quick point of clarification. On Esther Street, there are addresses that go from 3302 to 3320 Esther Place. And within that, there are a few of these that do have certain conditional uses, 3314, 3306, but that's it,
Where are these addresses?
the ones that he just read.
Yeah, I've got that there were prior cases for certain addresses on Esther Street. Now, one
Those
thing that would,
addresses, if you pull them up on SDAT, though, what do they produce? Also
they
not
would all go to,
3305.
yeah, I mean, as I understand it, these are all portions of the larger long
Yes.
property, which is known in SDAT records as 3305
Right.
East Fayette Street.
Right, okay, I understand.
Mr. Vittori.
All right, thanks. Get back to,
Sorry for the interjection.
had it all.
another one too.
That's it. Don't worry about it.
All right.
As far as the adverse effects, that are associated with the service garage here, do you feel like they're greater at this location than they would be anywhere else in a similarly zoned property?
No.
And then, can you describe why the establishment, location, construction, maintenance, and operation of the conditional use will not be detrimental to or endanger the public health, security, general welfare, or morals?
I could.
Is it for the reasons that you already stated?
Yes, sir.
And do you know if the property is located within an urban renewal plan or some other plan that controls what uses can take place there?
I believe it is.
Okay. And do you know whether the board should, any other reason why the board should not authorize, if the board authorized this use, it would be contrary to the public interest?
I don't, no.
Okay. And is the authorization to use the entire site as conditional use for service garage in harmony with the purpose and intent of the zoning regulations?
Yes, it is.
That's all the questions I have.
I have a question on the, this is the Google Earth, I guess it is, photo you showed us. And your properties are on the left here, is that correct? It's on this side.
Right. Those are both Mr. Zappardino's properties. The other ones on the other side were Mr. Fishbein's properties.
Well, I'm saying, the ones that we're here about today are these,
Right.
correct? Okay.
That's right.
So, we've got a number of vehicles lined up there. Where is the city, where is the right-of-way? Where does your property stop, and where does the city right-of-way start?
I'll have to refer to my lawyer. I'm not.
It's just outside the garages. I think that's indicated on the plan that we entered into as an exhibit.
Well, yeah, I understand, but
Sure.
I'm trying to get
His
a
perspective.
visual, you know, as to where, if you put a car in front of the garage, where does that car line up? And for example,
Sure.
if you look at this 10 car, it looks like there's a curb cut or something like here, and I'm wondering, does the city right-of-way start here?
As I understand it, and I'm not, title attorney, I didn't look at that aspect of it, so I'm not offering an opinion in that regard. But where these cars are parked, for this picture that, who knows when it was taken, 5 years ago, whenever, these cars are the issue, I think, that the community has a concern about. There's what is loosely called a sidewalk. It's more like a ramp going up to the garages, and I think, what Mr. Smelkinson is here to attest to is that he understands the cars can't be out there. I think it's kind of what you think of as staging area.
Yeah.
One of the conditions that the planning department wants is no staging, no work on vehicles waiting to go in. So that way, people that wanted to walk by the garages could walk by them without a car being in their way. And I
And
think
Mr.
we're
French, does
aware
that-
of that, and we'll at least concede that point, that that is what we're considering was staging, that we're not going to do that. Correct.
Mr. French, is that the
Yes.
planning department's understanding as to the right-of-way that's being referred to and the condition that's being offered?
Well, planning staff have noted in the past that, at least along Fayette Street, which is a quite busy street, there have been both blockages of the sidewalk with vehicles being repaired and vehicles awaiting repair, and blockages of the curb lane of East Fayette Street by vehicles being repaired or vehicles awaiting repair. There have actually also been A-frame placard signs put out to advertise services at a specific garage in the street. And we have no record that there has ever been a minor privilege permit obtained for the purposes such as that. On the Esther Place side, we aren't so sure because, as they've suggested, we're not certain of where the property line runs in relation to the pavement. And that would be something that a title search would have to determine.
Okay.
And just to that point, is the discussion that you heard Mr. French just gave her the editorialization about what has transpired. Was that on Esther Place or some other street that he was commenting about cars parked?
I think Mr. French was referring to two different areas. One was the Fayette Street, which we're really not, and I think the other lawyer, David, the lawyer, on the other side, his side, said that they're not concerned about that side. What they're concerned about is the Esther Place side. I don't want to confuse matters anymore, so I'm just going to leave it at that.
Sure.
Okay.
How about this? As far as the Esther Place side of the property, as you saw in the Google Earth, which exhibit number was that, Mr. Vittori, do you recall? Was that 4? Appellants 3, okay. There's it shows on the left side of the photograph, I guess, your property that fronts on, or the portion of your property that fronts on Esther. And there are cars that are not in the bay, but are parked on the, I believe Mr. Vittori referred to it as a ramp area.
Mm-hmm.
When you discuss this with your tenants, are you telling them that they cannot have any vehicles in that space as well, or just not vehicles out in the street?
Based on the citations we received last year, and we then went to the environmental and paid those citations, I was told by Mr. Crippen, okay, who's one of the, Mr. Crippen, works for Baltimore City. He issues citations. He says, look, you got to park your car like you do on a normal street. You can park it horizontal, not perpendicular, right? So that's what I told my tenants, and that's what they've been doing. And then the other day they came and they told him, in fact, that you can't do that. It's a little confusing as to what they want us to do, because police come and say one thing, and then the Baltimore City Code Enforcement says another. But we're willing to do whatever they want us to do, just let us know what that happens to be.
Yeah, it's a little confusing, as we've all said, but you know your property better than any of us here. From the end of the garage on Esther Place, how far out does your property extend until you reach the city right away?
From, oh,
You cross the
Thank-
precipice of the garage.
right, I think it's,
Is it 5 feet, is it 8 feet, is it 3 feet?
sorry, I think that I'm not qualified to answer that question.
I think the record can reflect that it's not very far. I mean, it's not a foot, more than a foot, if anything.
Okay, well, that's what I'm trying to get.
In all likelihood.
Okay.
Just
And
the point.
I'm not disagreeing with that,
Okay.
I just don't know.
If this would help the board, so what I have here is another aerial photo of, from Google Maps that shows the Esther Place. This is what, Clinton and Highland, and then here's the area, so. Do you have any
I think
questions?
what we really need is an IOLTA survey that shows exactly where it is, but I think we can agree that it's not, you know,
Right.
what's depicted.
So I guess to end my inquiry, there can't be a car parked outside the garage without being on city property, no matter, there's just not enough room. Is that fair?
I don't think so. I think the reason why is because
don't
if you
think
park a car like a normal street, as if there were a sidewalk there, and then you park the car next to the sidewalk or in the street, there's room for at least one car on each side of the street, like there are on most city streets.
Okay.
So then you can park your car, say horizontally to the building as it runs from north to
But
south.
you can't have cars perpendicular as are in that photograph,
To the street.
which lined up with each garage.
You cannot, as they
cannot.
used to do for 40 years, they cannot anymore because then technically you're on city property, you're on the sidewalk, so to speak.
Right. So I'll just go ahead, and I think this is just a little bit more clarification to the board. You can see where here you can see where the Esther garage ends, where the building itself ends, and then you can see the sidewalk. The sidewalk runs in front of it, and then you can see cars essentially parked on the sidewalk, which would be also referred to as the city right-of-way. And I think they're acknowledging this, and then beyond that is the street. So you can see cars parked, what I would say illegally, right there in this picture on the sidewalk. And I think what they're acknowledging is those cars should not be there. Anything basically beyond the line of the garages is the public right-of-way, is the sidewalk, and there should not be cars parked there.
You want to submit it?
Yes, please.
All right. Mr. Torrey, yeah.
That's all the questions I have.
Mr. Smelkinson,
Yes. Go ahead.
to address the question that a board member, I don't want to mispronounce your name, is it Bonaventure?
Bonaventure.
Bonaventure. What Mr. Bonaventure was asking you earlier about was your enforcement mechanisms with your tenants. Why haven't you taken any enforcement with your tenants thus far in response to the citations that you've received or in response to the Planning Commission's report, which they haven't complied with?
I mean, how do you know I haven't?
Okay, what have you done?
Well, I've been forced to, that's why the cars are all parked the way they're parked, and if they're not, I go down there almost every day, if not every other day, to enforce it.
Well, what is that enforcement mechanism? What does that consist of? What are you doing?
Excuse me?
What does the enforcement mechanism consist of that you've taken so far?
Well, I make sure, I threaten them if they'll lose their lease if they don't, if they continue to park that way.
When did you first make those threats?
So, about a year ago.
Okay, and has anybody changed their behavior over there?
They've all changed their behavior.
If I were to show you photographs that were taken yesterday that showed cars parked in the middle of the street, cars being worked on in the middle of the street, cars being parked on the sidewalk, would you be surprised by that?
Well, it depends because when you've showed me a lot of pictures in the past, okay? We've done this, we've been down this road before, okay? And a lot of times you show me pictures that aren't by tenants.
My question
that are
is,
other
would you be
people.
surprised if I showed you pictures taken yesterday that showed cars parked in front of this address, these addresses, with work being done in the middle of the street and on the sidewalk by your tenants?
Look,
Would that surprise you?
Nothing surprises me, okay? I'm
Okay.
55 years old,
Then
nothing
what-
surprises me in
if
this
that's
world.
if that's happening now, what enforcement mechanism will you take tomorrow?
Well, it depends on the picture, and it depends on who was under the car. If there was actually, there's a lot of things that have to be considered. It's not as cut and dry as the way you would like it to be.
Okay, so essentially what you're saying is you haven't actually done any enforcement. You've warned them, but nothing's been done. You can correct me if I'm wrong. You've warned them, but nothing's been done. And then your plan for the future right now is wait and see. There's no enforcement taking place,
You're
correct?
putting words in my mouth, but that's not what I said, okay?
Okay, so what are you doing? You can correct me.
I'm sorry, I don't want, I've already answered the question.
Okay. Okay, in which bays is automotive repair already going on? I'd like to show you a picture of the, if I could have that exhibit back, actually. Thank you. All right, if you could just, Mark, hold on here. These are the garages that you own from here to here, is that right? These from here to here?
Yes.
Okay, all right, so what I'm gonna do is I'm just gonna mark an X at one end and an X at the other end, okay? And what I'd like you to do is mark an X over every bay where automotive repair is currently taking place.
Can I give you a pen?
Oh, I'm sorry. Okay. Is it? Okay, now which addresses, which Esther Place addresses are these? I mean, well, let me, I'm sorry, let me back up. How many bays are there right there? How many total bays do you own?
All of them.
I know, how many is that? How many?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I think it's about 10 or 11 or 12.
11 or 12 bays?
Yeah.
Okay, and there's automotive repair taking place in 4 of those?
No, no, excuse me. Some of these bays are at least, this bay right here is at least 4 bays is one person.
Okay.
So there's one company there, there's one company here, there's one company here, that's 2. There's another company here, that's 3. There's another company here, 4, and then the end has, so there's 5 tenants in there.
5 tenants. So
Right.
5 tenants for 11 to 12 bays. How many tenants are performing automotive repair in their shops?
Well, they're all, I assume, well, automotive repair, yeah, they all do different types of auto repair.
Okay. How many of them are repairing engines?
You know, you'd have to ask them. I mean, I think they, as far as I know, is, to me, you know, it depends on what you refer to by repairing engines.
Could I just
Yeah.
remark for the record
Yeah.
that council's writing on the
Sure,
exhibit
I'm
as
writing on the
opposed to,
exhibit.
it may not be clear from the record that this is taking place.
I would say, just to make it easy, let's say they all are repairing engines.
Yeah.
But, you know, some do tires, some do oil changes, some do,
How many are doing spray painting of cars?
A more efficient way to do this might be to establish whether or not he knows
I think it's
various
interesting
operations.
that he doesn't know.
Well, but I think that if there's, you know, I think that it's certainly understandable if a landlord has a commercial property, they may not know, certainly without resort to records, what businesses each of their various tenants are engaged in.
Certainly. Do you know what kinds of automotive repair are taking place in the bays?
just standard auto repair, such that you would do it, you know, any auto, like a Midas.
So everything, full service?
I don't know if they're all qualified to do full service, but, you know,
Okay.
that's, I hope they can.
For the
Okay.
record, just object to kind of pinning down these specific uses. I mean, ultimately, the use that allows under this zoning classification allows repair, painting, and engine rebuilding as part of the conditional use approval. So if we're going through each of the things, I mean,
Which conditional use approval are you talking about?
what's that?
Which conditional
On the
use?
ones that apply to the entire property, 3305.
Do you have the case number?
What's that?
What case number?
Well, there's not case number.
I might have that here.
1789. There's
Wait, wait.
220-03.
Yeah, we got
There's 598-06. There's
all these.
283-07.
We got all these uses, 1, 2, 3, 4,
Right, but
5, 6.
Most of those,
7, 8.
again, all right, we won't get back into that. Okay. I apologize. Mr. Snelkinson, how often does auto repair occur inside of the bay doors with the bay doors closed on your properties on Esther Place?
Objection to relevance.
It's quite relevant because the planning department's recommendations specifically say that it has to take place either behind a screen or inside the bay with the bay door closed. So
That's
how
a
often?
Crawford condition.
Correct. So how often does that occur?
How often, yes, okay. How often does it occur with the door closed?
Yeah.
Well, it's because I'm not there all the time, I can't really, I'm not
You
qualified
testified
to
a minute
answer.
ago that you're there almost every day.
I said every other day, but not all day.
Okay. So how often does auto repair take place with the bay door closed?
If you know.
I don't know.
Okay. Now, you testified that it's kind of full service, basically more or less in the different garages. What's the interior space of each one of those garages, if you know?
I don't know.
Is it much bigger than my arm span? I mean, is it about the size that one car could fit inside?
Well, you have a pretty big arm span.
I do,
so,
that's
yeah.
true, that's true. Well, let's say you had a car parked inside, a regular sedan, Camry. How much additional space is there inside the unit once a car is pulled inside of it?
There's I'd say another 2 feet, maybe 3 feet, 4 feet. About 4 feet.
4 feet total?
No remarks from the gallery, please.
Okay, I'm gonna say 4 feet.
4 feet total? Okay, so once the car is parked inside, you've got 4 feet? All right. What utilities are established in each bay? And by that I mean water, sewer, et cetera. What utilities do you have established inside each bay?
Every bay has water, every bay has electricity, and every bay does not have HVAC.
Okay. What about
Can I
sewer?
ask where this line of questioning is headed?
Sure, I'm just trying to get into it's the impossibility of the performance of some of these conditions.
I would object.
Well-
I mean, the standard for conditional use applies to properties being impacted outside of it, not the individuals within the
Yeah, I mean,
actual property.
Okay.
I will clarify sort of the consideration that's right now in front of the board. This is a conditional use case, as I think you both have observed. Conditional uses, as I'm sure both of you also are aware, are presumptively valid uses under case law from our courts of appeal. And so therefore, the consideration is whether or not the use in the particular location that it's being sought is any more burdensome there than it would be anywhere else within that zone. So I've realized that that adjacent to the zone, there is an R8 use, but those properties aren't really in question. It's whether or not the use is any more burdensome within that particular zone
And so
where the property is located. And under the code, looking at 14204, required findings, the board may not approve conditional use unless after public notice and a hearing on consideration of the standards prescribed in this title, it finds that, one, the establishment, location, construction, maintenance, operation, blah, 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 will not be detrimental or endanger the public health, security, welfare, or morals. Two, the use is not in any way precluded by any other law, including an applicable urban renewal plan. Mr. French, I don't believe that we're looking at an urban renewal ordinance. Thank you. Three, the authorization is not otherwise in any way contrary to the public interest. And four, the authorization is in harmony with the purpose and intent of this article. And then in 14205, there are a number of required considerations. I won't go through all of them, but I will read off just a few. As a further guide to its decision on the facts of each case, the board must consider the following where appropriate. One, the nature of the proposed site, including its site and shape and the proposed size, shape, and arrangement of structures. Two, the resulting traffic patterns and adequacy of proposed off-street parking and loading. Three, the nature of the surrounding area and the extent to which the proposed use might impair its present and future development. Four, proximity of dwellings, churches, schools, public structures, and other places of public gathering. I think that we've established that the adjacent properties, though, are within an R8 zone. There are other garages that are there, and then there's a busy commercial street that's on the other side, with a Royal Farm that's there on the corner, or some kind of gas station operation. Accessibility to premises for fire and police protection, et cetera. So those are really the issues that are in front of the board. I do hear the opposition as far as the problems that have been occurring that I think that you've proffered at this point have been occurring at the premises. And I don't think that there's really been much to counter that from the applicant. But all of those things that we've talked about aren't either in the required findings or in the required considerations or are factors under the case law that we must consider. They are certainly informative. I leave open the question whether or not they're dispositive of the issues. We do, if you gentlemen both turn around, you'll notice that there is a full room full of folks who are here. So I would urge the both of you to kind of hurry up.
Okay, two points. One, as quick as I would like to be, I've been in these hearings before, and I've waited a long time. These, our matter is as important as everybody else's. I think everybody in this room, while they'd like me to hurry up and finish up, they'd also like to have a full hearing on their matters. But
That's
you
true.
pointed
and
out.
I will point out that we have, I believe, one member who will need to leave by shortly after 5 o'clock.
I have people in my group that need to leave early as well.
Okay.
But there's two of the things that you just mentioned are the nature of the site and the negative impact on the public, okay? What we're discussing right now is the nature of the site and why it has a negative impact on the public. Because each bay is so small, too small to perform auto repairs, they're forced into the street, forced into the sidewalk. It's why they can't comply.
I think those are
and
the
that's why
nature
it's
of the
relevant.
structures in the site.
Right, and that's the nature of the structure. The nature of the structure is too small to accommodate auto repair.
Well, I think that there certainly is some precedents out there authorizing certain of the properties in question for use as auto repair and different auto-related uses. So whether or not, this board isn't really qualified in auto repair, operation of auto repair garages and the like. If someone who's operating or looking to operate an automotive repair operation wants to pick out a site and they believe that it's conducive enough for their purposes, I don't know that I'm qualified to dispute that. If there's some sort of expert testimony that you can come up with that'll say that they're experts in automotive repair or design of industrial spaces, such as auto repair garages, and that there's some inadequacy of the space, that's certainly a consideration.
Sure, I don't think that I need expert testimony. Let me show him a picture. Mr. Smelkinson, this is also from Google. This is a picture of one of the interior bays of your garage, right?
Yes.
Okay. Now, I'll show this to the board. You can see the car.
This is like, okay, 5-year-old picture, but yeah, that's actually the picture, but it's about 5 years old.
Right,
Okay,
but
go
does it
ahead.
accurately represent
No.
the size of the interior of the garage?
Okay, but that tenant's not there and that tenant's not there.
Okay,
But that's
what
not
is
the
size?
question.
Okay, yes, it does.
Okay,
Yes, it
all right,
does.
so I'll just show this to the
Yes,
board.
okay.
You can see the size. There's exactly enough room for a car and very little else. Okay.
Disagree with
How?
the characterization of what is depicted there. It is what it is. The picture
So
stands for itself.
Let me ask you, if you can get and that's going to be my next question, if you can get a car into a garage and the owner of that business makes the business decision that working on that one car, and let's not assume that they're going to park at the city right away, but working on that one car is sufficient for that business owner's business, that's within the permitted use of that structure. Would you agree?
If they can do it within inside the permitted structure, right? Let me show you another picture.
He's looking for that.
I got it.
We cited case law, and we didn't seem to agree that the citation to case law was sufficient. So one such case is Montgomery County versus Butler.
I'm going to object.
417 Maryland,
I'm in the middle of my,
271.
if you want to make argument later, that's fine, but not right now.
Your editorialization get to the point of.
Okay.
Okay. So this was also taken on Esther Place, okay? This is a picture of an engine removed from, I took this photo. This is a picture of an engine removed from a car, sitting on the street, in front of the garages on Esther Place. Now, I would submit to you that you can't get this crane to remove this engine inside this bay at all with the car. The only thing you could do would be to park the car, maybe with the hood facing out, put the crane on the sidewalk, and then use the crane to remove the engine. There's no way this crane and this engine can fit into any one of these bays. That's my point.
But that wasn't the question. My question was, if a business owner wants to operate inside a garage and that fits his business model, and maybe you can't have it, would you agree that that is within a permitted use for that garage?
Can you repeat the question? I'm sorry.
Okay, let's assume that, using your example, let's assume that a garage owner doesn't have a way in the garage to remove an engine with that apparatus.
Right.
And park the car fully within the property line of the garage. If that business owner wants to run a business where he doesn't remove engines, therefore he doesn't need that. He has a business, and I'm not all a repair person, but he has a business replacing spark plugs. And has enough room in there to do that. Would you agree that that is within the permitted use of that garage?
Yes, if and only if it were to take place either behind a screen or behind a bay door, which it never does.
Well, those were planning conditions.
Right.
Now, that's not.
No, that's it.
not what the zoning code says.
I believe
The zoning code says within the boundaries of the property.
within the boundaries of the property.
Right.
I don't believe that that's correct, actually. I mean, I can point it out. It's in the letter written by the Patterson Park Neighborhood Association, which I authored. But there are statutes, and I can pull them out now, or we can talk about them later. But that are very clear that the screen is required, or it has to take. I'm sorry, either indoors or behind a screen. And
Well, I'm saying
indoors.
I'm saying indoors.
Well, right, but to me, indoors means in the door.
Well, you may have that interpretation. I'm not sure I share that with you, but indoors means within the property itself.
Okay, I guess then what it comes down to are those two different interpretations.
And I object to his editorialization that based upon those pictures, which show roughly 3 units, that not one of the, as I think the testimony was, 10 to 12 units, garage doors,
I have pictures
could
of them.
possibly accommodate this.
I have pictures of all.
And I'd be happy to offer a witness that can testify about the particulars if
Yeah.
you'd like, but.
Okay. Mr. Smelkinson, how often does work take place on the sidewalk and in the road in front of your buildings?
If you know.
I don't know. If it does, it's not supposed to at all, actually.
Okay, so you don't know. What hazardous materials are used on site? By that, I'm referring to oil, transmission fluid, coolant. Do you know?
Well, you can use a hazardous material as long as you dispose of it properly. I don't know. Don't know the answer.
What containment methods are used for hazardous materials on your site, if you know?
You have to ask the Department of Environment because they're the ones that regulate that.
Okay, so you don't know.
No.
Okay. Vehicles that are not being worked on at the moment inside the garage, if there's not a vehicle that's being worked on, where can those vehicles be stored?
Across the street, because there's 182 garages, a lot of my tenants rent those garages and store their garages on that property.
Okay, but you don't own any property where they could be stored?
Yes, I do. The whole entire property in the center is full of parking spots that they can use.
Okay, then why are they stored on the sidewalk and in the middle of the street?
I mean, I don't think they are, but if they are, then that's a violation.
Do you think it's possible to screen off these garages from nearby residences?
Absolutely.
Okay, where would you put that screen?
Well, you can put it right down the front where there's a screening material that I have researched that you put down the front that.
Where are residences located at?
Excellent question.
Because I think that we established that across the street in Esther, although that is a residential zone, that all of those properties there are garages. I do see what looks to be houses beginning on maybe, is this Highland Avenue? South of the intersection with Esther.
These are all the residences that have an eyeball view going on here. If I could,
Hang on
Mr.
one
Chairman,
second.
what
Let me talk to my client.
Sure, go ahead. Oh, go ahead.
He's showing these lines,
Right.
I guess this one, however, kind of pairs off with these lines.
You can get a peekaboo view of the
Garages from there, okay.
We're having an off-the-record discussion.
My microphone is 3 inches from your faces.
I do understand that when the two of you are talking, you're not having an on-the-record discussion.
Thank you.
Mr. Washington, if I could,
You do.
this is the same exhibit as before, but with lines showing the residences. This is an exhibit that I also created, but which I can have my witnesses testify to. Every red line essentially represents an eyesight from a residence to the garages.
So you'll notice here, these are all residences. Right across the street, yes, directly across the street, these are storage units. But here on Highland and here on Clinton are properties that face this. This is a business here, but these are all residences here, here, and here. So every one of these lines represents a person who has a direct line of sight to these garages from their home, from their residence.
I object to the exhibit because it doesn't show the distances, and it's prepared by this witness that, I don't remember what it reports to show and how far these pictures are accurately.
I can have my witnesses testify to.
I think
to their
that we
location.
can,
For the limited purpose of
I think that
people can see it.
from simply looking at the picture that the location of residences is patent, I think. And the board can understand that those are the closest residences,
As long
which
as
is
you
where
give
I
the
was
way it
asking.
deserves, I'm sure you
As
can-
far as sight lines and things like that, I think that the question is whether there's sight lines that go inside the premises. So certainly, someone who's all the way down at the other end of Esther Place at East Avenue, I guess, and Esther Place, I'm not sure that they would be able to see into the garage, but nonetheless, we do note the location of where the residences are. This is an exhibit that's.
Yes. How many citations have been issued to you in the last year related to this address?
Last year, Mr. Crippen issued citations to every single tenant for not having the use and occupancy, which we then went to court and found that they all had use and occupancies. So
How
the citations were not, nobody was found guilty, they were just given citations.
Were you personally issued any citations for this property?
I believe the rule is that I got a citation and every tenant got a citation, but I'm ultimately responsible for them.
Okay. So you didn't receive any your testimony is that you didn't receive any citations that you actually had to pay?
We did. I brought them with me. You know what, there were some citations that we ended up paying due to some confusion on the names and I think the specific and peculiarities of the way that the use and occupancies had been written up and some minor changes that had to be made, I's dotted, T's crossed, various things like that, that they ended up reducing the amount, and I paid it. I didn't want to argue. I just paid the fine.
Okay. What were the uses that you were supposed to stop doing under the citations? What was the citation telling you to stop doing?
There was nothing that there was told to stop.
Okay. What were they citing you for? What were they telling you was the illegal use?
It was just not having the proper U&O, that's all. It wasn't illegal.
Question. You referred to proceedings in district court?
No, these went to environmental court.
Okay. All right, so the citations themselves went to environmental court. You contested them in some way?
Environmental Control Board, they were right here. I have copies of them right here.
Okay.
I was referring to zoning citations.
The environmental, if I could,
Yeah.
the Environmental Control Board, when code enforcement goes out and issues citations, they're the ones that ultimately consider whether a violation occurred.
Frankly, the appeals are more expensive than the fines are, so it kind of doesn't make any sense. If you lose there and you file an appeal, you're spending more money than it's worth.
Certainly. So you appeared before the Environmental Control Board
But it's only one
regarding.
individual.
Okay. You appeared before the Environmental Control Board regarding the citations?
Yes, I did.
Okay. And I hear you correctly that as a result of those proceedings, the Environmental Control Board found that there were no violations?
There was a compromise. The way the court worked is the judge there agreed and disagreed at the same time, and therefore compromised and gave me a reduced fine. But I don't know, I'm not, I think I'm not of the expertise to tell you exactly what the procedure and what the actual finding was, because I'm not a lawyer, but.
Would it be safe to say it was cheaper to pay the fine and make it go away than to contest it?
Well, right, sometimes it's just less hassle, put it that way, to do it that way.
Could you take a look at these citations from Baltimore Housing and from, it looks like from the zoning commission.
Look at these. These are Baltimore Linwood. That's not my, okay, I see here, 1, 2, there's like dozens of them here. Or at least 2 dozen. They're not my,
Aren't those citations issued to your property?
well, this one is. They're all use permit required. Each and every one of them.
Okay, yeah, that's not all of them. Keep looking.
It says.
There's
use
multiple
permit.
pages.
Oh. Well, they're all, these 2 pages are use permit required, and then these are just copies of the citations in individual form.
Keep going.
Okay? These are copies of the same citations over again.
Okay.
All right?
And your testimony is that you didn't pay any of these citations?
No, I just testified that
You
we
did
paid
pay.
every single one of them. Yeah.
And so what was it you were supposed to have a permit for that you didn't have a permit for?
Originally, the tenants had to as some tenants left and some tenants came, the tenants' use and occupancies weren't in their proper names, and the names had to be changed in various forms like that. And there was, for each individual citation, there was a story behind it. I don't want to, take the time here today to go over each and every one of them, but there was a compromise reached in that court that the judge agreed would be fair.
If you know, how is particulate matter from body and paint shop work and welding being handled, emanating from the garages? How is that taken care of?
Objection.
Is that a separate?
Have you been qualified as an expert?
No.
No, well, I'm just wondering
If you know,
if there's ventilation. I'm wondering if there's ventilation.
That's, okay. I think what you're asking.
is there ventilation inside
Oh, yes,
of
there
the
is,
unit?
of course there's ventilation.
Okay, thank
Of
you.
course.
All right. The direct of this witness, I think, went on for maybe about half an hour. The cross-examination has gone on, I'm sure, it's been over now. We do need to get to other witnesses.
I'm
in
fine
other
with
cases.
I'm fine with them calling the next witness.
Okay.
Thanks.
No, so he's gone? He's gone. Oh. Oh, could you get him? You want to call police?
Did you, I mean, he was going to testify about other things, or?
Oh, no, I don't, it's
We have other
redundant.
witnesses.
It's redundant.
We're fine.
Okay.
Okay. My first witness is Alicia Porter.
Share my microphone, his microphone.
You can
Get your
stand
own.
on the other side and use that microphone there.
All right, Alicia, just if you could, just say and spell your name.
Alicia Porter, ALISHA, PORTER.
Okay, and where do you live?
I live on 3201 Esther Place.
Can I see the exhibit with the lines drawn on it? Could you show the members of the board and just kind of take it around to them? Show them exactly where you live on that map.
Could you mark it? That'd be too much.
Well, I can tell you, it might be easier than marking. I think might be easier to tell her, well.
I'm an appellate judge, so looking at it, the mark would probably be more helpful than
Yeah, no, I hear you.
reading a transcript.
The lines are red, so.
Yeah, so the orientation here is, these are the Esther garages.
Okay.
This is Clinton Street. That's east. Okay.
If you intend to have others mark it, maybe come up with a 1.
No, she's probably the only one I'll have. Okay. How long, what is your address?
3201 Esther Place.
And how long have you lived there?
Since 2007.
And what do you do for a living?
I'm a project manager.
How often do you drive or walk down Esther Place?
Every day.
And is that in the area of the Esther garages that we're here talking about today?
Yes, it is.
Okay, so you walk down there every day since you've lived there?
Yes.
Okay, describe for the board, if you could, what you've seen driving, walking down the street.
So the main concern that I have is that entire area is typically blocked by cars. So I understand that just one side of the garage is his, but both sides will have cars on the street being worked on, along with tow trucks, many tow trucks, and along with just cars that are, to me, look abandoned. They eventually do move after sometimes weeks, but they are severely damaged cars. So they look like they've been in major car wrecks. So severe front-end damage, missing engines, often on blocks. So the main thing that you would notice if you were driving in this section here is that if you're in a car, you're very rarely going to be able to just drive right through it. You're going to need to stop, and you're often going to need to wait for someone to come out of the garages and direct traffic and say, hold on, and I wait for someone to pull out of a garage, and we have to kind of negotiate to get through this stretch. And that's every single day on this block.
So you see disassembled cars parked on the sidewalk?
I do,
What about on the road?
yes.
Now, is this just on Esther Place, or are there roads nearby Esther Place where these cars get parked?
So yes, I mean, I'm on my block alone, so I am a block away from these garages, and in front of my house, I get overflow cars. So I get tow trucks leaving cars that are wrecked cars in front of my house, often. And also on side streets. So on Highland, you'll see cars from that. Next to the Royal Farm area, you'll see cars that are being dumped there. So it's all around. It's truly all around my house that's being affected.
Okay. And actually, could I have, you've taken some pictures of the area?
Yes.
Okay. Could I see those? And I guess just to save time, can we just have these admitted rather than go through when they were taken and et cetera, et cetera? Okay. But it's safe to say that the photos that you took were all taken within the last year and a half?
Yes.
Okay. And what do the photographs show?
I think we can see what the photographs show.
Okay. Are pedestrians able to walk down the sidewalk on Esther Place on the side where the garages are?
No, they're not.
Why not?
If the garage is open and working on cars, there are cars there.
Are the bay doors?
Just to be clear, we're talking about the current condition of basically the situation on the ground
We're talking about the condition.
currently and as it has been, correct?
Correct.
For 7 years up until yesterday.
Okay. And again, going back to the considerations the board has to look at, just so that we're clear, we have to look at the proposed use, and we have to consider that proposed use in light of the conditions which the planning department has offered and which the applicant has conditionally, I think, accepted at this point.
We've talked about the negative impact on the public, correct? That is a consideration
The negative impact on the public of the proposed use.
of the proposed use.
So
Correct,
it's
yes.
prospectively looking, not retrospectively looking.
And so you're saying that the retrospective behavior of these owners for the last 7 years is not relevant to that
If
consideration?
you can point to me somewhere in the code that we can hang our hat on in making that finding,
Mhm.
I don't see one as I look at 14204 and 14205. And in light of the case law on conditional uses.
I'll just continue my examination for the record then. Are the bay doors to the garages open or closed when work takes place?
I see doors open often with work being done. I don't know if they're working.
Again, is there a requirement in the code that work be done with a door closed?
The work has to be done either indoors or in a screen. Now, if the
And
board
I
is
think that
telling me,
Indoors, I think there was an earlier exchange on this point. I think that under the code, indoors means is simply within the four walls of the structure. I don't think that I saw a requirement that the doors, windows, et cetera, be closed.
sure. Where does the work take place besides the four walls of the structures?
Often from what I see in the street, which is in the pictures.
Can I just concede that all these witnesses are going to say work takes place out there?
this point.
That would be helpful if we had that
Perfectly
proffer.
Sure.
Fine with,
Are you-
we're all gonna proffer that.
Are you going to concede to the spillage of hazardous materials on the sidewalk, oil?
Absolutely not going to concede to that.
Okay, well, then we're going to take some testimony on that. Alicia, you took some photographs of the sidewalk area. What can be seen on the sidewalk area besides just concrete?
Oil spills, antifreeze, just liquid that looks dark, and then all of the sidewalk there is stained from years of things being dripped. Oftentimes, when they hose, the bay's out, it'll trickle all the way down to my end of the street, so.
Can I see the exhibit down there with the?
Ultimately, it's somebody enforces those issues, and if it's not somebody, and we're, again, looking prospectively, not retroactively to what has happened. And can she honestly say that every one of these vehicles, that anything that's come out of has all been on account of this garage versus other businesses? Or-
I think absolutely. If I could
Okay,
see those
yeah.
exhibits, I'll show you why.
Stand corrected.
Just the map, actually, the map, yeah. Can I see actually the blow-up map, the one that's a little bit larger? The one, that one right up, yeah. Great. Okay. What I'd like to show the board is the condition of the sidewalk. If you look at you can see nice, clean, white sidewalk in the area leading up to the Esther garages. As soon as you get to the Esther garages, it's completely black. It is completely black there because it's completely covered in oil and other hazardous materials. If you just look closely at the sidewalk, you see
Well,
that.
that's.
I object. It is a
You're
conclusion.
I think it's, I
Perhaps
think
it
it's,
happened 50 years ago and it hasn't been changed.
I will accept that the sidewalk is a different color. I can't tell you why it's a different color, and I don't think anyone standing here can tell us why it's a different color.
have you ever seen fluids leaking out of a vehicle being worked on outside of the Esther Place garages?
Yes,
Do you know what the fluids were?
oil and antifreeze, typically for a car that has severe damage.
Can you see these garages in operation from your residence, from the front step of your door? Can you look down and see these garages in operation?
Yes, I can see the garages. I can't see into the bays of the garages, but I can see what can be performed on the cars.
Okay. Outside in the street and in the sidewalk?
Yes.
Okay. Between the garages and the nearby homes, is there any place where a screen or barrier could be erected between the garages and the homes?
I don't believe so.
Is there anything that you can smell when you're near the garages?
Sure. Paint fumes is a pretty consistent smell. Burnt welding, whatever the burnt smell of welding is apparent.
Okay. Those are all the questions I have for him.
Ma'am, you moved into your house when?
2007.
2007. Okay. That's all.
Question. A key indicator, I don't know if you testified, but you can state unequivocally that every one of these oil stains came from this garage.
Absolutely not. No, I can't state that every
And
single
have
one.
you made any complaints to an environmental agency about these leakages that you?
I raised it at I went to Township Park neighborhood meeting and said that they were starting an open investigation for the garages.
That's all the question.
I don't know, given the indication of the board to save time, I mean, I can proffer that every other witness here would testify in accordance with Ms. Porter's testimony. I don't know that they have anything to add other than. Sure. If everybody who was going to testify today could stand, I'll just tell you their names. Patrick Lumberg, Matthew Gonter, Jennifer Broadway, Rachel Timmons, Steve Preston, Aaron Chilson, James Chilson, Julio Calderon, and Carlos Plazas.
Okay.
Would have all testified exactly the same way that Ms. Porter did.
And
And they
have you
all
said the
also would testify that they live very close to the area, and they have this. They live and go down Esther Place. Just as we are all the ones impacted by the Esther Place garages.
And each one of you has signed in on the signing sheet? Okay, all right, so we can use
And
that.
so then I'll just offer additional photographs as exhibits. Thank you. So if I could just quickly read from Jim Kraft's letter. The current application for approval of these garages as a conditional use would reward the owner for having operated his business in a harmful manner to his neighbors for years. My office has also been involved over the past several years in attempting to get the owner of this property to comply with the existing zoning and use requirements of his property. He has continually failed to do so. And we're just going to see more of the same. So I think you already have copies of these, so I don't need to submit them. But I would like to submit additional photographs showing the condition, copies of the citations that have already been issued to Mr. Smelkinson.
I have no objection to the pictures without any additional context of anybody to cross-examine as they show pictures that they may have been that date. And I'm sure there's additional circumstances that somebody could address individually, but I won't take up the board's time.
And more photographs. And
Again, without anybody testifying about the photographs and having an opportunity to cross-examine them, these are given the weight they deserve, I guess.
And then the emails from Daniel Smelkinson to me stating what the condition of the property would be, as well as the email from his counsel to me stating what the condition of the property would be. And again,
Mr. Smelkinson, to give this some context, if at all possible. Call him. I don't know what the emails say.
the highlighted portions are all I care about.
My email says-
There are additional photographs.
There's more photos.
Yeah, but the dates are important because you'll see that some of these photos have little sticky notes with dates on them. A lot of these photos were taken after the promises were made in the emails. You see the email saying, "I'm going to do this now." Nothing changed. There is no enforcement over there.
Are you offering these as well?
Yes. And lastly, just with regard to the requirement for the screen, the requirement that it take place indoors and that there be a screen, I would point the board to Baltimore City Zoning Code 6-405B through C. Servicing must be located within enclosed structures. And to me, enclosed means the door is closed. Screening is required for any use that is not conducted wholly within an enclosed structure if the use either adjoins or within 100 feet of a lot in a residence district and is visible from the ground level of a residence, which all these people would testify to. This requires a wall, fence, or other substantially equivalent structure at least 6 feet high to screen these uses from the view of residences. Again, this Baltimore City Zoning Code 6-405B through C. So for businesses in a B3 district, which is what this is, that is the requirement. Not indoors, but enclosed.
I believe Mr. Smelkinson's testimony on that point was he was looking into getting a screen for the front instead of having a hard garage door to keep whatever's inside there safe. But instead of the garage door being up, you would then put a screen that you would be able to see inside, and that would satisfy the spirit and intent of ZCPC Section 6-405. So we have no objection to that condition, and we'd even be happy to go with planning and make sure they're okay with what the screening looks like, if I could speak so boldly for Mr. Smelkinson.
And which ones he wants screened, exactly.
We'll present options to him.
And I do have just a
I
few
would
closing
point
remarks,
out
if I
that
could.
Enclosed structure is defined under the code. 1-139, enclosed structure. Enclosed structure means a structure that is separated on all sides from the adjoining yards or other open space, or from other structures by exterior walls or approved party walls, pierced only by normal windows and doors.
So technically, we could have the door open. We'd still be amenable to the screening if that would be a condition you and planning would want to add. We wouldn't have an objection to that, correct?
Well, again, I think what it says is separated on sides. I think that's separated on all sides. I think that's the key language, and there's no separation if the door is open.
Pierced only by doors or windows.
Pierced. And I would just add, as far as the conditions on conditional uses that required and suggested conditions, that in Eastern Outdoor Advertising Company versus Mayor and City Council of Baltimore, 128 Maryland Ave, 494, at page 525, that the court held that when answering conditional use questions in Baltimore City, the DMCA is required to apply the Schultz versus Pritt standard. And also, as I was citing earlier, Montgomery County versus Butler, 417 Maryland 271,
It states at pages 291 and 307, Judge Harold, preeminent judge that handles most of the land use decisions that come out of our appellate courts, found that absent codified provisions of contrary, there's a presumption under the law that a conditional use, i.e. a special exception, is presumed to be in the public interest. Presumption of validity. And to defeat approval of same, it must be established that the inherent adverse effects associated with the use would be greater at the proposed location than at other similar zones throughout the jurisdiction. You have no evidence before you what other impacts would be experienced at other jurisdictions, but you can assume that the inherent adverse impacts here are also going to take place elsewhere. So while
No.
these adverse impacts here, that's fine. You can share your opinion in a moment. That's my position on it. I think, again, we satisfy the criteria. They had a obligation to rebut the presumption that this use is permitted here. And if that is taking this as a matter of first impression going forward, but I still think also the prior approvals, and this is more of a housekeeping item, that we had a conditional use approval and we are cleaning it up at this point, and we're happy to put it entirely in Mr. Smumpetson's name. He's the one who lives or dies by the sword on this. If he can't get himself in order by these conditions, then there are provisions in the code that conditional uses can be revoked if those conditions are abided by. I have made him aware of that. He understands that, and that's where we are today.
With regard to the impact here being worse than in other areas, I think if the board takes notice of where the residences are here as they are compared to other B3 districts where this could go, this use is right next to and within the line of sight of many, many residences. People who try to walk through the area every day and can't, or drive through the area every day and can't because it's completely blocked. If this was in an area that was actually a commercial area instead of a residential area, and I understand the way it's zoned, but the point is this immediately abuts a residential area and it immediately impacts that residential area. So if this were in another location closer to other businesses of the like, then it wouldn't be a problem. For example, the Fayette side of this very same business. We've already talked about how the Fayette side of this very same business is not as impactful on residents as the Esther Place side is. The Esther Place side is a nightmare for every one of these people here that have to interact with it every day. And that's why, of course, it would be better someplace else. All these people came here to testify what a nightmare this is for them. It wouldn't be a nightmare someplace else, any place else where there are fewer residences. And so the prospective use here is just going to be more of the same.
I don't think the argument is, but for every zoning area, there's a boundary. For every B3-2 zoning area, you have a boundary, and a lot of those abut to residential areas. I mean, how far do you keep moving back the zoning so it doesn't abut to a residential area?
And that's,
When do you stop?
yeah, and that's why these uses are within this board's discretion. The board has discretion to take note of those boundaries. Yes, there is a boundary there, but that boundary is important. The board should take that boundary into consideration. Like, how far do you move it back? That's exactly what's within your discretion.
But
You
we
know, you should
also
consider.
have to counterbalance that by the authority that council pointed out, that these are presumptively valid uses. And so while the board might be inclined to sympathize with you, just to be clear, all of the members here on the board live in the city. Certain of us live in areas that might even be bordered on 3 sides by busy commercial streets. I would be that person. I don't know about the others. So I hear your arguments. And though the board may be sympathetic to that position, the board still has to operate within the law and operate within the bounds of the authority that council has indicated. So we have to balance those and try to find a way that we respect both the rights of the property owner and those of the community. And the way that we do that is by looking for those answers either within the code or in other items as precedent with their cases and the like to consider. So I just want that to be clear, that the arguments that you're making aren't necessarily falling on deaf ears, but the board is a board that does have to follow the law.
I have no additional comments.
Thank you.
All right, thank you. Okay. Next, 2015-157, 6327 Green Meadow Parkway. Ms. Junker. Howdy, folks. You folks had an opportunity to have a discussion. Were those discussions fruitful in any way?
They were fruitful but not resolvable. Karen?
I think so.
Okay. Ms. Junker, we have this as an application to raise the existing dwelling and construct a new two-story detached single-family dwelling with parking pad in the front yard. Is that correct?
That is correct.
Okay. Can all those intending to give testimony raise their hands? And be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I affirm.
Okay. And do we have staff reports?
Yes, first we have a letter from the Cheswold Neighborhood Association. They write that they have been presented with the plans for the proposed construction and that the association is in strong support of the project. We have received correspondence from Councilwoman Ricky Spector indicating that she wants to support the position taken by the Cheswold Neighborhood Association, and she urges the board to heed and approve the appeal. Does planning have a report?
Thank you. The planning department has no comment on this application.
Thank you. Okay, Ms. Junker.
Just in case anyone wanted to see the letters, here are the two letters that were referenced from the Community Association as well as from Councilwoman. At this point, what we are requesting on behalf of the property owner is to raise the existing structure and to construct a new, expansive, two-story dwelling unit. And that is what, it will be the residence of, excuse me for 1 second. We submitted the other day, Mr. Henry, we updated the site plan. Did the new site plan get onto the record? Yes. Okay. All right. So the proposed resident of this property would be Rabbi Eichenstein, and he is a religious community leader of the synagogue that's being constructed immediately adjacent to the property. And his intentions are to live in this dwelling as a religious community leader, and as a religious community leader and a man of a highly religious observation, be able to reside in a home that will allow for large gatherings of extended family members as well as religious community members. And the purpose of his home will be for his primary residence with his family, as well as to be able to host on behalf of his religious observances, as well as to host community members in his home. We have letters from several residences within the community regarding the proposed construction. That I'd like to submit, if you wish to review those. And the plans and the intentions have been presented to the Community Association and to the Councilwoman, and have been posted and conveyed to the community.
Tell me about the parking space. You're gonna come in off of Green Meadow Parkway, it looks like a curb cut here.
Well, there's actually, if you look at the plan closely, the curb cut is an existing curb cut. So it's already an existing curb cut for a zero setback that already currently technically exists, because you can't get a variance for parking in the front of the property, so instead you have to have a zero setback variance to allow for the parking to be in the setback that no longer exists. So really what we're asking for are variances for lot coverage, front yard setback, and rear yard setback. And so by virtue of the existing parking space being in the front yard, we already have a zero front yard at this point under the existing conditions. So we're maintaining that curb cut for it to be a pull-in, so you would be parking.
That was my question.
Yeah.
How does it work?
So you would be pulling in and turning to the right, okay? So, but that actually goes to one, I'm sorry.
You get out, then you're gonna back out of that?
Yeah, but you have to back out of the space anyway. The space functionally already has the same constraints and challenges that exist under the current parking conditions. And furthermore, the setback for the front yard that we're asking for technically is one that we already, by existing conditions, are already in violation of. So we're really not asking for any further relief in that capacity for that setback.
And that kind of gets to something I was looking for, is that, you know, you talked about that you're looking to build a, I think you call it an expansive residence. And
We know that it's very large, like I'm not trying to
sure,
deny that.
I'm trying to get an idea of the, of what's being proposed in relation to what's already there.
Okay.
Both as to the driveway, which I had a question about,
If you look,
and how
well,
big
let me show you.
of an expansion we're talking about
Well,
both.
turn back to the site plan. You'll pull slightly closer to me, I can help you. If you look, this is the existing driveway. So we're using the existing curb cut to pull in and out of that spot. So you already have
Okay,
this,
right
and this is what is the existing home that's being raised.
Okay.
Okay?
So this hashed area.
Yes.
And then this outer line.
I can't speak to that, give me a
Well,
second.
No, because that's the
No, that's
patio.
patio and stone porch. It's this hatching line is the footprint. You see
Okay.
this? It's hatched here, and then to the rear is the patio area that
And that's the
exists.
fo- Okay.
So that's the existing footprint.
Okay.
The existing footprint includes the patio area, the existing structure is
Is
that.
yes.
And the
Okay.
existing driveway comes off of this curb cut. And like I said, the zoning code does not allow for front yard parking. So you can't variance front yard parking, you can only variance front yard setback. So we already have a 0 front yard requirement based on the existing conditions.
Just to give the size, guess, a feel for the size, I mean, my rough numbers, it's about 8,400 square feet. per
Your
acre.
rough number, not, your rough numbers. Give me a second. Yes, that is correct.
And the proposed building line is
The dark line
this
outlined on this plan.
there.
That is correct.
Okay.
Question. Did I read correctly in your opening that there was construction of a synagogue next door?
Yeah, on Baythorn, catty corner to the property. Torah Markaz, if you look on the site plan. Here, this is area. Where- Right here. This becomes Baythorn over here. So you have a corner here, this property is where the synagogue is being constructed. And I can't tell what I'm looking at according to that data map. But the point is that the residence is being constructed for the rabbi to live next door as the religious community leader for this congregation.
The site plan looks like it's next door, this aerial photo looks like there's an existing residence next door.
Well, no, that's the synagogue that's being built. So if this is, I can't tell from the date of this picture, this is in 2011. This has since been, this is clearly outdated because the synagogue is under construction.
I think I was remiss. Did we have staff reports in particular? Did we have anything from Mr. French?
Oh, thanks. Not for a single family dwelling.
Okay, so that's, yeah, that's
Thanks.
helpful.
Thanks for that. Yes, and this is the.
Fascinating.
And what's this? Oh, this is great. Does the general public have access to this on the website or no?
No, that's a license, it's a proprietary product.
Of course it is. Absolutely. I understand how that works. But thank you. It's very good. What else? on that?
Okay. So you've acknowledge that you're that you are looking to build a extremely large building on this property. It's about a third of an acre lot,
That's, yes.
and it's going to cover most of it.
60% of it.
Yes. Looks like there's gonna be along the side, between, looks to be like 10 feet along the side, widening to maybe about 15 or
That's-
more feet along the side, and then 10 to 15 feet along the back, and then again on the other side, looks to be consistently about 10 feet.
10 to 20 on the front, 10 on each side, and 10 to 15 in rear based on where the lines fall.
Yes.
We're not here for side setbacks. We're completely within the allowable setback variances for the side. Again, the front yard setback that we're asking for, we technically are already in a 0 setback condition. So the new variance from the setback perspective is the rear yard setback, as well as the lot coverage.
And this is a variance request, so what's the uniqueness and hardship is with a traditional variance standing
The
to?
uniqueness and the hardship is, in 1971, when the zoning regulation was last revised and implemented, and I believe codified is the right word, the community conditions that exist today weren't really in existence back then. And the Jewish community has evolved and started moving into the area in a way that certain religious observances are restricted in some of its functionality. And so, as such, there are more and more congregations being established that are very neighborhood-centric. And so the religious leaders serve as religious community leaders, as well as residents, and as well as congregant leaders. And the type of functionality that the different religious observances has, based on their degree of religious observance, have different community type of operations. And the community that this congregation and this rabbi/leader oversees requires a type of living arrangement that allows for him to be in proximity to his congregation, as well as to have the facilities to be a leader of his congregation, and due to the family size that this leader and multi-generational religious follower has, to support the use, location, and operations of his role within this community. So the purposes are, there are no properties in this area. You can't just get up and move to the countryside, because the whole premise of this religious observation, or the whole premise of this of the type of lifestyle that this congregation's observers adhere to, requires a very densely populated area in terms of functionality. So to have the land area that would support this type of functionality as his role as a religious leader would actually then take him out of the environment in which he is leading of the community. And that's what some of the letters state, the importance of him being so close to his congregation. The location's important, and you won't really find properties that would allow for a structure of this size to not trigger any of the variances that it would require.
Okay. Don't the
So the
factors,
uniqueness, I'm sorry.
But don't the factors for variances really focus on the property as opposed to the unique situation of the particular owner? I mean, if, say, someone's a follower of the quiverful evangelical Christian movement, and that's the sect that they Duggar family belongs to.
Okay.
They believe in having large families, is what the quiverful kind of refers to. Okay, so someone could say that, that they're a follower of that religion, and that that wasn't, a prominent sect in 1970, whatever, when the code was written. And therefore, they're in a unique situation and they need a bigger house because they're going to have 19, 20 children. And wouldn't that person then, irrespective of the board being able to determine, are you going to actually have 20 children, what have you, wouldn't that person be in a situation, or wouldn't they be in a situation where they would be able to get that variance where their neighbor wouldn't be able to, simply because of their religious belief?
Well, I'm not arguing it's the religious belief of the resident, and therefore he's entitled to it because that's his religious practice. What I'm saying is that the community itself has become established within the last 40-some years. And some of the needs of some of the representatives of that community who leads and guides and implements the practices of the community members has certain requirements that other people may not have. So am I saying that because of this faith, they're entitled because they might be? That's really not what we're asking specifically. I'm not saying we're not playing the religious card. What I'm saying is that the community itself has evolved in such a way that it wasn't planned, but if you take this community and you move it to a different area, the size of the properties in the R1 district in this area are kind of self-contained. So the larger properties really aren't available within the area that the community itself is already established. So are you saying I'm describing the uniqueness of the individual as opposed to the uniqueness of the site? I would say sort of. But the fact is the properties in their existing condition in this zoning district in which this community has evolved, not decided to locate, but has evolved, has the self-imposed limitations due to the nature of the properties in this area currently.
Question. Often we get drawings of floor plans in more detail than what's in my package anyway.
Okay.
Do we have that?
I have some. I had something put together to bring. Normally, I don't always have floor plans, and these are not final, I'm sorry.
I mean, I guess my basic question is what's being proposed is a single-family residence here, I assume, right?
Yes. Because a lot of functionality, here you go, Ms. Bonaventure, is also predicated based on the gender usage. A lot of the layout is still being designed. Does everybody have 2 sheets?
Explain that for me. Gender usage.
In certain practices, men and women have to function independently of different space. So a lot of the space, and then also because of the kitchens, there are multiple kitchens in an observant home. So we have the Passover kitchen on the 2nd floor, we have the primary kitchen on the 1st floor. So we have layouts still being established. The lower level is not final, but that's the basement anyway, so that doesn't impact the zoning. But this is, right now, the starting point of how the house is going to lay out, and that's the 2nd floor that you're looking at.
Okay, anything else?
I'm sorry?
Anything else?
Not yet,
Bolton
no.
position? Okay. If If you will go first and then
Okay.
just state your name and address for the record, please.
My name is Yael Eliashmarani. If you look at
Spell that.
A-L, first name?
Yes.
Y-A-E-L, last name is A-L-Y-E-S-H-M-E-R-N-I.
Mr. Reporter, together?
Corrected that.
Correct. Thank you. It's 2303 Gerard Court. So we are the court that backs up to this property that they're talking about. For the record, I just want to say that I'm representing all the people on the court who are opposed to this whole project, and that is because we understand, and I'll read this from many people close to the project, the reality is they will be a social hall. So if you notice that dining room, that's not just a dining room housing his parties and get-togethers, it's housing the parties and get-togethers for his entire congregation, free of charge. Ritual bath, that will be in the sub-basement, so that doesn't have to get any approval. Hospitality home, that would be upstairs. And people close with the project say he has no intention living there. Actually, the synagogue, which is right next door to it, they built the synagogue, which is presently being built, is around his dwelling. So they could have raised the whole property and built the synagogue. His dwelling, that's where he dwelled before, is extended now, and the entire synagogue is built around that. So the intention, underlying intention, the sign says, as you have it here, the sign around the corner says, raise the existing structure and replace with new 2-story single-family dwelling. So anybody who is familiar with the English vernacular would assume from that, never assume but, that a family is coming into and living there. That is not the case, and that is not the intention. And that is what's disturbing to us. On the sheet, the sign-in sheet says also with parking pad in the front yard. There's space for 2 parking spots. It's not for a whole parking, Right now, it's quite, if you will, chaotic, the parking just for the synagogue. Now, just for the record, 5 years ago, we and the entire court signed to have the synagogue there. We had no opposition. We both are religious members of the community, and we have no problems with synagogues. My husband goes to synagogue 3 times a day. That's not the issue. The issue is what's being presented to the entire board and the entire community is not what's written there. It's written as such that it appears to be that we are having this family living there. And in fact, he is stating, the rabbi is stating, well, I am entitled to have as many guests as I want free of charge. I'm not going to charge them. That way, I'm entitled and I won't be violating anything. In addition, the court that we back up to has, at this point in time, there's 16 children under the age of 16 and under, and grown. I'm doing 2 months, so is my neighbor. That will make 18. There are many, the reason why we like the cul-de-sac is because the children ride the bikes, they play outside. I always put out like a little slow man with 2 cones, so very on it as far as safety-wise. But this would, as it is, as Mr. Hain could attest to, because he lives right next to the synagogue, the parking is impossible, if you will, at this point. With the social hall, in addition, the parking, the hour, late hour, music during the week, what they intend to, which is not written on the sign, it's kind of read between the lines, will definitely disturb the children on the block, the whole piece in the neighborhood, and I feel like anybody in their right mind who lives where we live would oppose to it. Many of the people in the letters that you got, they live a couple of blocks this way or behind or in front, so it doesn't affect them like it affects us as it does now as far as the parking. I drive carpool, my children go to school in either direction. It is impossible. As far as the synagogue now, they park on either side of Green Meadow Parkway, and you can't get, there have been near accidents, people are making U-turns, blocking driveways, and there's no, for some way, there's no parking facility for the synagogue as it is now. And that's, what disturbs us. There's the noise, the loitering, there's a discussion that the plans for this ritual bath that are underway, but again, underneath the house, so it's not on the plans officially, would include perhaps a cut-through through my property, again, would be, I guess, with permission, but it was stated what person in good Jewish faith would deny synagogue goers or people who are trying to have a ritual bath and cut through. So trying to assume or sort of, I guess you, if you will, twist my arm and saying, well, what?
You can't just say no.
Right, but I'm saying this is what's being proposed to us. And the same thing when we brought up to Rabbi Eichenstein, well, what about the parking? He said, well, legally, anybody could park on any street. And what person in good Jewish faith would deny that? And that to us is sort of upsetting / disturbing and sort of, I guess, if you will, alarming that that's kind of, I guess, like I said, like twisting our, sort of kind of twisting our arm to say yes in this situation. We actually tried to meet with the rabbi. My husband approached him to meet as a group, and it wasn't a big group. It was just the people in the circle. So we have a small little cul-de-sac involving 3 families, and he said he would not meet with us as a group. Individually, he would, because he feels in numbers there's strength, and he wants to kind of deal with us one by one, which, again, to us is kind of telling. I pass it on to my neighbor.
Sir?
Okay, my turn?
Yes.
Okay.
If you could start off again with your name and address.
My name is Irving Hain. That's Hain. And I live at 6329 Green Meadow Parkway, which is directly next door to the site in question. I'd like to submit these photos, if I may.
Sure.
And,
Are these photographs that you took?
yes, this morning. I also have,
I have.
yes.
Thank you.
I also have a couple of other things that really just shows the synagogue schedule of classes and services and so forth. If it's okay, before I directly address this proposed plan, I think it's important to give you a short background of how this situation has developed and where we are today. My wife and I purchased our home 18 years ago. We moved into a quiet residential neighborhood, and quite honestly, we never expected to encounter the problems that we have now on a daily basis. A few years ago, Rabbi Eichenstein bought the house 2 doors away from us and began holding services in his home. It was a small group of people, and it quickly grew to the point where they made a decision to form a congregation and build a synagogue on his property. And that was supposed to be a synagogue with living quarters in the back for him. And that's how the synagogue is being constructed today. And the pictures show that as well. Even though we were less than enthusiastic about having a congregation 2 doors away from us, we did not oppose the building because we didn't want to stand in the way of a house of worship being built. In retrospect, we probably should have done so. We didn't realize to what extent it would affect us. We were repeatedly assured by the rabbi that steps would be taken to ensure that the entire situation would only minimally impact on us. Promises were made that were not kept. As a result, we have no confidence in any assurances that may be promised. It seems as if our home and the quiet residential nature of the neighborhood is a mere afterthought that doesn't deserve any consideration. Maybe this is how it works in a commercial environment, but this bulldozer approach does not suit a single-family neighborhood. Right now, the synagogue's under construction, and while it's being built, all the services, the classes, the study groups, all the meetings are being held at 6327. That has, for the last 9 or 10 months, essentially become the synagogue. We were not asked about anything to do with that. We were told, yes, we were told a couple of days before that that will be the synagogue until the main synagogue is completed. Now, if you look at the photos, yeah, I'm sorry. This one, hang on a second. This is a picture of my home, okay? This is a picture of the synagogue as it's being built. Now, this back area here, which is in the, it's not finished yet. You see the, I don't know what you call that, the drywall or whatever it is. That is the rabbi's residence in that home. And in fact, there's a slight addition on the back of it for a living room, which he did not have before, because when he purchased the house, he chopped up part of it to use it for his original synagogue, and then when he expanded, they needed more room. So that is being completed as his living quarters. Okay? This house is not his living quarter, this
New house.
this new house. Anyway, that's that one. This is a side view to give you an idea of how large the synagogue is. Keep in mind, it is actually 2 doors from my house. Now, this photo shows the synagogue and 6327, which is right next to it. Okay? This one, number 5, shows the synagogue, 6327, and the poor guy that lives over here is me, right next to it. Okay. This last one shows the distance between my house and 6327, which I believe the trees are approximately, you see that it's a line that goes back, that is approximately the property line. As it is now, classes in the synagogue start at 5:20 a.m. Services start shortly after that. They continue through the morning. They start again in the afternoon until 11:30 at night and sometimes later. At this time, there are 11 services per day, which does not include classes, study groups, or meetings. Most of the people attending services or classes arrive individually in their own car. This involves a large amount of people coming and going. The traffic is unbearable. There are times when it's impossible for us to get our car out of the driveway. Car alarms, horns are constantly going off. Every time someone locks their car, they press the button on their remote and the horn sounds. It happens early in the morning, and it happens late at night. People congregate outside our home and hold discussions directly in front of our bedroom window, which, as you can see on the pictures, is literally right next to the synagogue, the temporary synagogue. Our issue is not with those people that attend the synagogue. They are conducting themselves as anyone would who attends services anywhere in a public place. The fact is, it's just not suitable for a residential neighborhood. As you can imagine, getting a night's sleep is almost impossible. Number 7, which I have given you, that shows the time of the scheduled services and classes. I think it actually shows that the first class is at 5 a.m. But I usually don't hear horns until about 5:20. That's when. The last one shows a listing on the internet advising people that the shul services and everything to do with the shul is being held at 6327 while the synagogue is being completed. Which now brings us to the matter at hand. My understanding is that the zoning board is to determine whether or not the existing structure is to be demolished, and if a new structure, supposedly a single-family dwelling, is allowed to be built. The fact is, the new structure is intended to be more than a single-family dwelling, much more. My understanding, and I got this from the president of the synagogue, the top level is to be used either as apartments or temporary housing for people or classrooms, and the lower level is meant to be a large social hall that will be right next to the synagogue, and it's also to have a ritual bath.
And if you will, to just add on to your, the Duggars, I don't think even the Duggars would have such a big dining room. I mean, have you ever seen a dining room that size for a family? I mean, that's a family of 250 people.
A lot of synagogues do have social halls, and they are not made to sit idle. They're constant functions. Every individual synagogue uses their social hall as a source of revenue. The rabbi claims he's not going to charge. I don't know if he is or not, but the fact is that they're constantly rented out throughout the Orthodox community. Many synagogues have them, and they are rented out by individuals. They're rented out by groups and so forth. The noise and the traffic as it exists now, just with the services and the classes, is unbearable. With a social hall, every night of the week, probably, music, crowds, traffic, and just a few feet away from our house, from our bedroom window. Now, I do have to admit that the rabbi did offer to make an accommodation for us. He offered to board up our windows. I don't think that's probably relevant to the zoning issue, but I think it gives you an idea of what we're up against. The ritual bath, we refer to that as a mikvah, M-I-K-V-A-H. In this case, my understanding is it'll mostly be used on Fridays. It's a Jewish custom for many Orthodox men to use the ritual bath on a Friday afternoon before the Sabbath. And there are several of these mikvahs throughout the Orthodox Jewish neighborhood. This may sound like a minor issue, but it's not. Not if you're living next door. I recently visited one of those mikvahs in the Park Heights area. I was there on a Friday afternoon, and the roads were impassable due to the heavy volume of traffic. I am certain this pattern would be repeated again on my street. And I don't relish the thought of parking 2 blocks away from my home. Quite simply, this is an untenable situation for my family. Even without the social hall and the mikvah, it's become a very difficult and unpleasant place to live. If you allow the social hall to be built, it can only get worse, much worse. We moved into this neighborhood to live a quiet life. No one should have to live like this. I respectfully ask that you take this into serious consideration when making your decision.
Thank you.
I'd like to also, if I could submit this.
Mr. Chairman, I have a question for you. It's a follow-up from Chairman Washington's question to you about the hardship presented here.
Yes.
I heard your answer. By my, again, very rough calculation, by right on this lot, you can build a house of approximately 6,000 square feet, and this is very approximate.
No, 4,200, because it would be 30% lot coverage.
Okay, so 4,200 square feet.
Mhm.
Can you explain to me the hardship that your client would experience by not having 4,200 square feet and going to 8,400 square feet?
Yes, and I'm perfectly happy to explain away again. First of all, his extended family alone is well over 200 some people, and we're just going through to the first cousin level. The nature of his family's history, he has a large extended family. So the religious practices and observances go multi-generational, and the size of the families that have come from each generation have been large, and the number of children have had also a large number of children. So by virtue of accommodating just a simple holiday gathering for his own extended family, as a religious leader and as the head of family, would result in a large number of people. So a 4,000 square foot home would not be enough to comfortably accommodate somebody who would be frequently hosting religious observances and celebrations in his own home. Second of all, I liken this, let me step back. We're here for a single family dwelling only. That's all that we're here for. Any of the nuances and nuisances and any of the areas of concern that are being alleged or being discussed and complained about currently are tied to an existing condition of the synagogue. They don't transfer with each subsequent property. They're existing. The operations that are listed here are for a synagogue that is being constructed on a different property. And they don't duplicate, replicate. No, it was a single-family dwelling, and the development was to expand upon the structure because it was cheaper to build upon the existing structure than it was to demolish the structure in its entirety and build all new.
Yeah, I'm just saying, do you disagree with the opposition that there is not a living quarters being built in the synagogue?
My client has told me and has only told me, and all I ever have heard, and the only thing I know, other than what they're telling me, and I can't take what they say as accurate and what my client is saying is not, I firmly 100% believe that they are moving into this property. I have absolutely, you can keep those. I was just using those as reference to the fact that this all references to uses in operation for a synagogue that's approved. Is my client building a single-family dwelling to reside in it? 100%. I truly believe that that is what is happening, because that is only what I've ever heard from my client, that he is building a single-family dwelling, that he is moving into it, and his family is going to be residing with him there. He has expressly stated to me that as a religious leader in the community, and as a part of a large extended family, that there are expansive uses. Yes, the dining hall it looks massive. But I live on the east side of town. I live east of Charles Street. I have moved from Homeland to Rogers Forge, and I am very familiar with the size of the properties that exist in Guilford and Roland Park. And I do not see this any differently than a CEO living in Guilford or Roland Park hosting a political fundraising event for any purpose that would have a large number of people gathering in his home for a personally represented and supported event. So I don't see the difference between whether he serves as a social host to members attending a function in his home, or the head of Care First, Blue Cross Blue Shield, having a large political event in their home, whether it's Green Spring Valley, whether it's Roland Park, whether it's Guilford. He is entitled to personally host events and provide for space and accommodations for that purpose.
Is there a difference as to frequency?
I can't speak to the frequency. I can't speak to there being a schedule. I can't state that he intends to hold specific regular events there. I can't speak to that because that is not something, A, that I know of, B, that I can even commit to. I can't confirm or deny the regularity. If there's restrictions that need to be imposed, so be it. That's fine, because part of the zoning decision, it becomes legally binding. But I can't stand before you and say that I'm withholding from you the knowledge that he's going to have events every Friday, every Tuesday, every Wednesday. I don't know that. I am not withholding that information from you. I know that my client has come to me, has come to the firm that I am employed by. He wants to construct a single-family dwelling for his family to reside in, to host members of his extended family for holidays, because he's not leaving and going away for the holidays. He is the head of his congregation, and he is here for all the religious holidays. I don't even know what they all are, but I know that they're extensive and numerous. But all that being said, I'd like to address some of the issues of concern, okay? Some of them were quite frankly, walking through someone's property is trespassing, pure and simple. So the fact that a fence would be put up in the rear of the property to prevent that from happening, that was already agreed upon. We called and spoke to the rabbi between our conversation and the hearing. He is in support of that. He's in support of landscaping at the property limits to help assuage some of the transferring of sound between the sites and to create also physical boundaries between the properties. There are things that he is willing to do that we have discussed and addressed to minimize the imposition. So if we have to extend the trees further between the two properties, between Mr. Hain and the property, to continue the buffer, to continue the increased illusion of greater space, that's 100% fine. Because if you look at the pictures and you see the trees that are between Mr. Hain's property and the proposed single-family dwelling, and even on the plans, you can see where the line of trees currently exists. They're noted on the site plan. You can see the landscaping is noted. To continue it, the setbacks, quite frankly, aren't even an issue because we're not asking for an interior side setback. So he's not in violation of anyone's personal space at the interior side level. The front yard setback, we already have a 0 front yard. The existing parking's in the front of the property. So even though we're stating that we're requesting a front yard setback, we are not furthering the degree of noncompliance by our additional request for a 0 yard setback.
But you are asking for variances.
We are asking for variances, and I'm getting to
lot
all of it.
area and for.
Not lot area, lot coverage.
Lot coverage, right? That's correct, because lot area, actually, you have twice as much.
Ironically.
But, you know, I just go back to the 15.218 and 15.219 required findings, and I know that you're well familiar with those. But, and, you know, I did hear your response to my earlier questions, but I'm still troubled by the, you know, the language in the code regarding that the board must find that because of the particular physical surroundings, shape, or topographical conditions of the specific structure or land involved, and the necessary hardship or practical difficulty would result. Your argument really focused more on the conditions that were particular to the person in the community within which the property was located. And then under required findings, the board or mayor and city council must also find that, one, the conditions on which the application is based are unique to the property for which the variance is sought and are not generally applicable to other property within the same zoning classification. So again, you know, depending upon what, if he wanted to move to Mr. Haynes' house, he'd find the same situation there. If he wanted to, I'm sorry, ma'am, I am blanking on your name.
Yeah,
but if she if he wanted to move to her house, the same situation would be found there. So it really just follows around whichever piece of property the person chooses to locate it. It's not
Which
a
shows that all the
uniqueness-
properties are uniquely disqualified to support the need for the community. And that the zoning code is somewhat outdated for the existing conditions of the community, and the delays in getting the Transform Baltimore approved to support the community
I don't
evaluation.
necessarily disagree with you, but this is what we have today.
Understood, and therefore, each of the properties you have described are unique in its basically conditions and
Then
limitations.
any property in the city would be.
Not necessarily, except the community doesn't exist in any other area of Baltimore City.
Well,
And therefore, any
there are a bunch of
other,
yuppies that live in my neck of the woods now.
but
and
it's not
they-
about yuppies,
but-
it's about community observances
Well,
and practices.
Sure, but it's about, what your argument is, it's about that the community that is located there currently isn't, it's different than the community that was formerly located there, and the code hasn't adjusted to reflect that more modern reality. And what I was going to say is that other parts of the city, you know, they were very industrial. They had working class folks who lived there, in smaller houses, lived there for generations. And in some cases may have had even large families, but they kept them in these little small houses. And people's choices change, and as folks want to live closer to the water, and they move into these formerly industrial areas, these little tall, these little
And they build these
small,
little
tiny
smokestacks with
houses.
periscopes.
That's right. And so, you know, they move in with, you know, their family of two, or they want to move in with their family of 2 or 3 kids, and the house now is too small. They want a 3,500 square foot house, and they live on a piece of property that has a house that's maybe 1,500 square feet of space on it. So they want to really explode the space, but it's outside of the both the lot coverage as well as setback requirements. People would be able to make that same argument in those areas as well. And I'm just trying to see if are you really just focusing on the circumstances of the individual and the community that surrounds it? Is there any, are there any conditions about the land that make it unique? Are there any, particular physical surrounding, shape, or topographical conditions of the specific land that's involved that would create an unnecessary hardship or practical difficulty if we don't grant the variances that are being sought?
practical difficulty that presents itself is that there are no other adjoining properties that are readily available to make the existing property in its current condition any larger than what it is. And the size and the specifications of the proposed structure on this existing limited-sized property that we cannot build any larger because there's no more property to build on, is the fact that there is no other property available to build in this capacity. Whether it's this property or any other property in the community, there's none that would support a structure of this size that would not trigger any other variances. Topographically, I can't say that because of the existing conditions of the soil, if we don't build on it, it's going to become a sinkhole and we're going to lose a child. I can't come up with anything significant that'll say that if we don't build on it, therefore it doesn't work. The fact of the matter is proximity is very important for the religious leader to be pretty much next to the institution that he is the leader of. There are no other properties that are available.
I'm not saying that the leader can't be next to.
No, I understand. You're talking about the structure and the structure. And I understand that. And the point in the practices that he intends to utilize his space for requires all the square footage that he's proposing. There were multiple discussions about the house, whether you go higher, whether we go whatever, and the layout of the space was designed specifically for use of every inch of it. And like I said, the limitations aren't that it's just going to be him, his wife, and however many children that they are fortunate enough to have. It's the fact that he needs an area to support his role, not only as a religious leader in his community, but as a family man, and the size of his family is extensive. So I understand what you're asking me is what's the unique hardship that is tied to the land itself. The unique hardship is the fact that the land can't get any bigger for the house to become any proportionately smaller in its coverage based on land area. So there is no bigger property for him to put the same size house to come up with a reduced footprint to negate the lot coverage variance.
How old, by the way, the rabbi and his wife?
Young, so they're not finished having all their children.
34.
So that to me is young. I'm 47. 47? Don't you love the way this is going? It's all relative. Anyway, so that's where we are.
All right. Any questions?
Can I add something?
Sure.
I'll be very brief. Okay. I also have a large extended family, and when we had a family reunion, we rented a social hall. Again, the president of the congregation mentioned to me that this is a social hall. The rabbi is not having regular Saturday dinner at 250.
Excuse me, I can't speak to the social hall component because this has not been discussed with me. And to close on that presumption is not fair because I can't prove a negative.
Well,
So if all we're doing is reiterating what was stated previously, I'm going to ask that we close
I
on,
was actually suggesting that instead of having
but we're not here for a social hall.
large enough to accommodate his extended family, perhaps when they do come to town, which to my understanding has only been once in the last 4 years, they can rent a social hall like everyone else does. They are in the neighborhood, it's within walking distance. He can still live in the place where he lives, which is in the synagogue.
And when you said we're not here for the social hall, that's exactly the point. We're not here. except
We're
we
here
are
for,
here.
okay, I was under the presumption that we were concluded at the conclusion of my closing statement in response to all their areas of opposition. Because if they're going to keep presenting new concerns, I need to close.
Frankly, the use, I don't really see as being a significant issue. Churches, synagogues, as well as community centers are permitted uses within the R1 zoning district. So, and I think that that the use that's being spoken of could possibly fit into one of those things if you were to say that it wasn't a single-family dwelling.
Right.
But that is neither here nor there. Is the issue really
Is the structure.
the structure itself and the lot coverage and really the variance issues. But thank you both.
Thank you.
That is
Thank
both
you.
sides. Thank you. All right. Okay. I have an unhappy announcement to make. Yes, on the way. It's 4:40. There are 2 members of the board who must leave shortly after 5 o'clock. One must leave by 5:15, another must leave by 5:30. Despite best efforts of first case took much longer than we would have liked it to. But that is going to have the unhappy consequence of making us unable to get to certainly some of the cases that are here today. We will try to get through the remainder of our cases that we have, but frankly, I am not optimistic that we will completely be able to do so. In any cases which we do not get to today, we will not have a quorum to be able to allow those cases to be heard today, and they will have to be heard on another date. Mr. Henry, if we can, I would like to prioritize any cases that don't get heard today to be able to be heard in 2 weeks. If that presents any conflicts, please let us know the next convenient meeting date so that we can get you scheduled. Again, our apologies for that. All right, next case, 2015-158, 1175 Sargent Street, Tekalegne Zia. Good afternoon.
Good afternoon.
And by the way, how did I do on that name? In short, poorly.
His name?
Yeah.
Hi.
He said, how'd you do on your name?
Gazal?
Gazal.
Yeah, G-I-Z-A-W.
Can we take ours and put me in for 2 weeks?
Okay. If you could just,
I'm sorry, you off the record.
okay. You can.
Because we're a couple of them down, and
Okay.
you just
Mr.
talked
Caduce,
about.
if you can just address with Mr. Henry, we can get you
I'm all right
scheduled.
with that.
All right, great. Thank you. All right. And ma'am, you are?
Keisha Bethian,
Okay.
representing the property owner.
All right. And Ms. Bethia, we have this an application to use the first floor as a grocery store. Is that correct?
Yes.
Okay. Can all those intending to give testimony raise their hands if you sworn, please?
Raise your right hand, please. Your right hand. Do you swear or affirm the testimony you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. And do we have staff reports?
We have one staff report.
Thank you.
Planning Department reviewed this application, noted that the property had previously been used as a tavern, but that its use has been discontinued. The application did not state how long ago this discontinuance had occurred. On that basis, the Planning Department has no objection to the appeal, provided that non-conforming use of the property has not been discontinued or abandoned. Thank you.
Hi. The proposed use for 1173/75 Sergeant Street is for a grocery store / convenience store. We're asking that the non-conforming use be changed to a B1 to allow the use per the subtitle 7. The grocery store is not prohibited by the Washington Village Urban Renewal Plan. We think that it will be a large asset to the community. The property was a tavern, as stated, and it's been out of a tavern for about 2 years. We're saying this is going to be an asset to the community. We know that there are other grocery stores there. We know that there's a Price Right not far from there, but the Price Right closes at a certain time. And the gentleman that proposed to use it to have extended hours so that the community could go to the store and get healthy foods at a later time instead of at the time. I believe Price Right closes at 8 p.m. if I'm not mistaken. I could be, but that's just what we asked, that to be changed to B1 so that they won't do any further construction to the outside if that has anything to do with it. From the talk that we had, that doesn't seem to be one of the issues. One of the other issues were that this is a drug neighborhood. There's already a lot of convenience stores, but we're not proposing that people sell drugs out of the store. We're proposing that they sell food out of the store. So that's it.
Okay. The property, you said, was last used as a tavern? Is that
Yes, and we tried to get it to be zoned as a tavern again, and they opposed it being used as a tavern, so we downgraded it to a C store, and so now they're proposing the grocery store, so I don't know.
Okay. And when was the tavern last in operation?
About 2 years ago.
Okay, about 2 years ago. Do we know if there's any? Well, we can get back
Planning
to it.
department is not aware of notices on the property, but we didn't look for those records.
Okay.
So there was a valid liquor license?
Yes, the liquor license just expired, I believe, February or March, somewhere around in
But
there.
I know, well, but did you have operations?
There was a valid liquor license on there. I'm just not sure when it expired.
But it wasn't being operated, obviously.
No, not in the past couple of years, not since it was acquired by my employer.
Okay. And when did he purchase the property?
I'm not exactly sure when he purchased the property. I believe it was in the last year or so.
Okay. But the tavern hasn't been in operation, you said, for about 2 years?
Absolutely.
Do you have any sense of whether it was more or less than 2 years?
I'm not exactly sure the exact date. I know it was approximately 2 years from what they said. They're saying it
2 to
was
3
more,
years.
2 to 3, and I'm saying 2, but I'm only giving you the information that I was given.
And sir, your name, Director?
Richard Parker. I'm the president of the Pigtown Community Association.
And you were speaking before about, I think you sort of used this interchangeably. You said a grocery store / convenience store.
Basically, because it'll be open later hours than a regular grocery store. It'll be a grocery store, but they'll be able to get, they'll be able to get things like as if you were going to a corner store as well, but like be able to get fresh fruits, fresh vegetables, things of that nature as well. Most corner stores don't have a lot of, fresh produce, things of that nature.
Mr. Henry, do we have any? Thanks. You had your hands full, I know.
Sanitation violation 10/2/2009. A sanitation violation on 10/30/2009. No vacant house notice. That's it.
Do we know what the sanitation violation was?
They use the word exterior. It's probably trash and debris and stuff like that. But that's conjecture. Could have been flaking paint.
What's inside right now?
Right now is the old bar and just the wall. It's two-sided, so it's about 1,500 square feet. So it's two-sided. So one side was like where there was a pool table. The pool table's gone, so it's just empty there. And on the other side is the old bar and the old wall that the owner just was about. I believe it was about to be knocked down. Then they stopped some type of structure. I don't know why it was stopped, but it looked like it was just an old bar and like an old refrigerator. Nothing new, just everything that was there when I believe he purchased it.
Are the places for the taps, are they still there or they've been taken out?
They've been taken out.
So there's just the bar.
The bar, just like the
bar,
physical
like
bar.
that.
Yeah, there's an older one that's not worked that just needs to be taken out. But none of there's no like the open. No, none of that. There's an old ice maker, I believe. But we weren't sure whether or not whoever was going to get it was going to use the ice maker or whether it was going to be operational. So we just left it. If it needed to be thrown away, it's easily to be trash removal.
Question? We'll turn to the opposition.
Sure.
Sir?
So our opposition comes from, one, the non-conforming use has expired. It's been about 2 to 3 years. Both Rose and Hines live about a block away, Rose even closer than Hines, to the old Rainbow Tavern.
10 doors away.
So
Your name for the record, ma'am?
Rosalie Martinez.
Is it Rosalie or Rosalie?
Rosalie. One name, Rosalie Martinez.
in addition, they're not serving a need to the community. Within 50 feet away from their proposed convenience store is an existing convenience store. Within a 3-block radius, there are 5 other convenience stores. Within a 1-mile radius, all still in Pigtown, there are 15 convenience stores. We don't have another need for another convenience store. So this is not something that we've expressed any interest in. They certainly haven't presented it to the community to seek community support or see if there was any interest. This is something that they've just chosen to do, and it's certainly not in the interest of the community. There's already just an oversaturation of convenience stores in the community. At best, we're trying to diversify the types of businesses and services in the community. We're doing well according to that plan in conjunction with Pigtown Main Street. Things like this kind of retard our efforts.
Okay. One question, if you may. Looking back at the permit history, this in '96, there was an approval to consolidate the lots. That is 1173 and 1175, and the first floor is tavern with offices and storage on the second floor. Do you know if the buildings were ever consolidated? Do they, like, is it open between them, or is it still the wall?
There's a wall, there's a door, actually, that you can come into. There's an apartment upstairs. There's an office on one side, and there's an apartment that you can come in, but the entrance for the apartment is through the gate in the back at the alley. So there, and
But
there's.
how about on the first floor?
On the first floor.
Do so the first floor of 1175 and the first floor of 1173, is there any way to get from 1175 to 1173 other than walking out the front door and then walking in the front door?
Yes, inside. There's a set of steps.
So
I don't even, I've never understood why it was two separate addresses. It just looked like one big address to me. I mean, I'm a girl, but. There's the door on the first floor. I'm still on the first floor. There's 2 doors. There's one door on the Austin Street side, and there's one door on the Sargent Street side. Am I correct?
Yes, but I think that the answer to your question is that there's a wall that separates the two.
But the wall is open. There's no door that separates the wall. You can just walk straight through and walk up a set of steps, and you're like.
There's only one door.
Yeah, there's
one door.
There's one door that you
That's
can
it.
go through and you get
2 to
from.
1173, one
Okay,
door.
okay, all right, so
One doorway. It's completely separate with one door.
okay, so you can get from 1175 to 1173 on the first floor
Without going
by
outside.
walking through a door
Yes.
that goes
Yes.
through the wall.
Yes.
Okay, that's what.
Okay.
And then what's going on the other side? Because I'm looking on your drawing here, and you've only got, or at least what it appears
I
to
believe
be.
they're going. That was where the wall is, and I believe they're going.
Oh, okay, that's the question.
Yes, that's that.
Well, this says that it's only 12 feet. Yeah, 12.3 feet.
Well,
So this is only one.
one side. This
For
is
one
you can
side.
ask that direct that question to this gentleman.
Hello.
Sure. Your name for the record, sir?
Last name Gzaw, Gizaw.
Okay, and you're the applicant, right?
Yeah.
Okay. All right, and Mr. Gazal? We're looking at the drawing that you've submitted, and we've got copies of that. Of the floor plan here, you can keep this. And since since 1175 is connected with 1173, I guess through this doorway right here, do you plan on any kind of operation or use being made of the other side that's in 1173?
Actually, this is the side. From here, there's 3 doors aside.
Okay, so this is,
Yeah, if you go from this side, there's there's a door, you can go through here, there's a two bathroom, is a first floor. There's a, you can go through this one to upstairs, so it's, first floor, second floor.
Okay.
And right here, there's separate, this door, this door, there's another door, 3 doors. This one's 2 doors.
Okay. Well, on the other side of this wall, is this a building or is this the sidewalk?
This one is the main sidewalk.
That's
the
on
sidewalk.
the street.
Okay.
Yeah, yeah. That's
All right. Okay. And so this is 1175, and 1173 is over here.
Right here, you know, where it's a cashier, right here, there's 1173 here. Right.
Okay. So,
There's a door, but there's no step, no nothing.
okay.
Just a wall.
All right. And so are you planning on using any part of
No, we're not gonna
1173?
use anything, only this one. We're not gonna use
Only
anything. That's why
1175.
This one cashier or display and everything here, because we try to use whether this door or we're gonna use whether this door, either door, and we're gonna put and make sure that there is safe stairs and everything, so people can access both way, whether this one or this one. So if somebody will try to go upstairs, they are not gonna come through the first floor or the convenience store, whatever, because they're gonna have access through this door to come upstairs. They are not gonna come here. Even we can't, if there is even wall, in order to get to the bathroom, you have to go through this wall. Right here, there's a wall in order to go to the bathroom. So this completely is by itself, it's just different.
Okay. All right. All right. Thank you for clarifying. I'm sorry.
So essentially, it's zoned residential at this point, and the community has just chosen to keep it residential at this point. We contacted Councilman Reisinger and had him do a walkthrough just so that he could see exactly what it was that we were asking him to take a position on. When he saw the close proximity, of course, he's very familiar. He only lives just up the street from this, but he walked through and he saw that the closest existing convenience store was 50 feet away. At that point, he was just pretty much sold. He did kind of peer into the building, continue to take a further walk through the community, and saw that just another block further was another convenience store, and the block in the opposite direction, 2 more convenience stores. So he was able to see that just by walking through. But we're not necessarily trying to cause anyone any hardship or anything like that. It's just the case that there's just an oversaturation. You all have it in your folders. A study that was done just over 5 years ago that talked about Pigtown's saturation of convenience store was markedly higher than the rest of the city. Where the rest of the city, it's kind of 9 persons per capita. In Pigtown, it's 14.9, and that's as it stands, or at least as it stood about 5 years ago. So at this point, we're just trying not to have another convenience store that does not serve a purpose to the community. The use as it stands is residential. No one has been in there for about 2 to 3 years, so that non-conforming use has expired. We just want it to remain residential.
Okay. And Ms. Martinez?
Yes.
When was the last time you can recall the tavern being in operation?
Almost 3 years ago. More to the end of 3 years.
Okay. And why does that stand out to you?
I live 10 doors away.
No, I mean, you said that it's about 3 years ago that you last saw it in operation.
Well,
So was there any event? Was there any like holiday?
But we knew
there
he was
any,
sick and that he was leaving. So
He was
everybody in
sick.
the community knows that he was closing. So we all knew it.
You said he.
The owner, Rainbows, we call him Rainbow. And we knew, everybody knew he was sick and everybody knew he was closing. So then it brought us to think, you know, what's gonna happen now? It's a bad place. And, I mean, I really like to talk more if I have a chance. I mean, can I give you my input on everything?
As to.
Why I don't want it there.
Well, right now, I'm trying to figure out when the last time it was in operation.
Okay, so it's about 3 years ago.
Okay. And sir, your name is?
Heinz Murray,
Okay. And Mr. Murray, your address is what?
1232 Glendon Avenue.
Okay. And when was the last time you recall the tavern being in operation?
It was approximately 3 years ago. I live right around the corner and I drive by it daily to and from work. I have to pass it in order to go. And because being involved in the community as well, we just pay attention to spots that are prone to issues.
Okay. And again, was there any particular event that you can?
Work that was being done on the inside, stuff was being pulled out, stuff, you know, it was, there were trucks, there was dumpsters, stuff was being pulled out. You could, I mean, it was obvious.
Okay. And you can recall, was there any, can you recall which time of year it was?
It was in the summertime. I would say August, September of, say, I'm gonna say toward the end of 2012, say August, September of 2012 is when that's when I can recall that I saw the work going on. Because we noticed that there were a lot of issues with Rainbow Bar. And so it was quite obvious when it all quieted down. And then we saw stuff being pulled out, and as she said, the owner, it was known around the neighborhood that he had gotten sick and that he was not gonna be around much longer.
All right. As pointed out by the report from the planning department, the issue here is it really revolves around when the last time the tavern, which was the last non-conforming use, was in operation. You can see that it was about 2 years ago. Your opposition pegs it more to 3 years ago, and Mr. Murray's testimony about the construction that seemingly was going on, you testified to some demolition that apparently had been going on, or some construction. Now that is also important, as those kinds of activities, removal of fixtures and the like, that actually establishes evidence of an intent to discontinue that use. And at that point, that non-conforming commercial use is abandoned. So both from the length of time and the fact that the fixtures were removed, the only remnant of the bar that's still there is the actual bar itself, but the taps were taken out, all of the tables, the chairs, I think you said the pool table was taken out, everything else was taken out, is evidence that establishes that the commercial use was abandoned as of that time. So once that has been abandoned, there's no pre-existing non-conforming commercial use that that would allow the proposed convenience store, grocery store use to be grandfathered in under. So I think that at that point, the board isn't authorized any longer to create what would now be a new non-conforming use of the location.
Okay. Thank you.
All right. Thank you both.
Thank you.
All right. And that's going to have to be the last case we take. So we're going to go off the record, and any cases that we have not yet gotten to, please, well, Mr. Henry, actually, take our vote. So please see Mr. Henry about getting the cases rescheduled. All right. I guess we have to talk about all three cases. He said he's got until 5:30. He's got to get here at 5:50. Yes. Well, that depends on how long we'll take to represent. All right. Fayette Street. It's a presumptively valid use. I hear them with the concerns that they have, but none of those points are part of the factors that we have to consider for conditional uses. I think that, as I told them, that I think that their hand is enhanced with the conditions that have been offered by the planning department, Martin, one other thing, did you guys have anything in there about hours? No.
But we can put it on.
Yeah.
Well, that was, and again, I agree with Jeff. I don't think that's required. If you have a door, you can have an open door.
Yes, and I think it's different where we have some of these operations where it's like a big lot and the garage is located inside the lot,
Yeah,
and you
that's
could
right.
like put a fence on the outside.
Right.
You can't do that.
We have done put conditions on that when it comes to the past that when people can see the point. And they very much can see the point, they do not put screens in.
I just don't know where you put it. I mean,
Well, I thought the same thing. That's the guy said he only had like a foot of ground between
yeah.
the wall and the
Sidewalk,
sidewalk.
yeah.
Without a minor privilege, you can't put anything on the sidewalk.
Yeah, I mean, they can't put like a fence that goes out that's gonna be a screen. I just don't see how it's accomplishable. I do think that,
We can't impose a condition that the doors stay closed.
I don't think so. Particularly not if some of the units are ventilated. I don't think that it would be safe at that point. But, yeah, I do think that we should put restrictions in on hours. I did see some of those photographs, work being done, it appeared to be at nighttime. And, that's true. And so, yeah, it just put in my mind that there should be a time after which that should cease. Whether that be 6 to 7.
A good example is the person, I can't think of his last name, the guy on Covington Street.
Yes. Oh, yeah, it's perfect.
Yeah, been there for years.
Yeah, and he's right in the middle of, there are a couple of those shops actually. So what's your preference between 6 p.m. and 7 p.m.?
I think it's difficult though. I mean, 6 p.m. it's dark in the winter, 7 p.m. is still light right now.
Yes.
So,
Well, I'm thinking more so as far as I see a potential hazard with cars being taken in and out into the street, out of the garage. It is tight space, both within the garage. We got that narrow sidewalk that's there, and it's a tiny street. I think that, that there are commercial operations that are on either side, but I do respect the fact that at either end are residential areas that people are going to be using that street to get to it.
And as it gets later, quieter, the vehicles carry. I would say 6 p.m.
I feel more comfortable if we had some testimonies or questions asked of either side about hours. We asked, were they comfortable with planning conditions that not include hours? And we got testimony on that point. So we didn't have any discussion at all about hours. I feel a little uncomfortable opposing those hours in the past. We haven't imposed hours. We got testimony on before, imposing hours. I just wrote a note that said, planning conditions, so certainly planning conditions should be a part of it.
I tend to agree, except that I'm balancing that with the question of how far do you push back the boundary because of the residential zone right up against the business zone. You can't push it back, literally.
Right.
So how do you address it? Ours seems to be a compromise way to sort of push the boundary back.
I'd be inclined to, I don't even know what the current hours are. It's not if I'm inclined to say.
8 p.m.?
Yeah, I mean, if the hours are 8 p.m., then I'd say keep your current hours, but comply with all the planning's conditions. And I just got the sense from that whole testimony and whole hearing, it was more of an enforcement issue. Because,
It
and we're
would
not the
ultimately
enforcement body.
be, yes.
So,
And we can certainly ask for supplemental information. We could ask them on Sunday, the hours that they're currently open. I mean, they may be open on Sunday, I don't know. Maybe it's good business. I don't know.
Good idea. Can you follow up with Mr. Vittori to get hours of operation. And if they're all different, find out, the latest that they go, and then, are their operations on 7 days a week. So find out what the current situation is. But other than that, I'm a yes with planning conditions and that.
Yes, same thing.
Yeah, just have to vote on the enforcement bill.
That's right.
Yeah. Right.
Yes, and then we just need information on hours of operation, and then we can figure out what we're gonna do with that.
Yeah, I think we'll probably should do that, so we get the hours.
Yeah. Yeah. All right, Green Meadow Parkway. I just don't think that it meets the requirements for a variance. I hear your argument as far as the need for it in the location, and if they want it to be adjacent to, close to it, not adjacent to the synagogue. As I said, I don't think that, I had the same reaction when I saw the great room / dining room, that looked more like a meeting hall to me. But regardless, when you look at the code, the community centers, churches, synagogues, temples are all permitted uses within the R1 zone. So if that's part of the community space or temple space, what have you, that's fine. But it just really gets back to the conditions that you need to satisfy for a variance. I just didn't see it. And I just see the reliance upon the religious circumstances, both of the property owner and the surrounding community, as a really slippery slope. And I'm not sure that there's room to accommodate that within the code.
I also think that if you look at the hardship argument, you can build a 2-story H1. Right.
Oh, much bigger than that.
I think that you may have a lot coverage area.
Well,
Going to-
it was, she said 30% to 14.
Square feet, yeah.
So you put 2 stories.
That's true, yes. Right, so, that was one. And then, for a sergeant, that's beyond our authority.
So is that Green Meadow?
So Green Meadow, I'm a no.
I agree. My thought there was that the hardship seemed to be more focused on the family situation rather than on the land itself. We didn't see the hardship. There was nothing particular about the land, other than the fact that accessible was you can't make land in Florida. That would apply to every plot of land in the city.
Yes.
So, I agree.
Okay. And Sergeant Street, I'm a no.
Right, agreed.
Sergeant Street.
I thought we already done that one.
All right.
All the other consents.
Yeah. Okay.
How did you decide on this? We're not used to this.
Sure. We voted against it.
Against it. Thank you. Thank you very much.
My friend said if
Sorry to rush.
I didn't get my way, say I'm having the baby right now. Right here.
Wow. We're not here.